Hello, 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 hello.
Jai Hind everyone. The speaker is on the way. We will start the inaugural shortly. कर दूं? Jai Hind to all the esteemed faculty and guests present here. I, Prerna Sharma,
And I, Raghav Agarwal, student of third year, welcomes you to this event on intellectual property rights at Ajay Kumar Garg Engineering College, Ghaziabad.
as we embark on this momentous event, let us commence with the traditional lamp lighting ceremony, symbolizing the dispelling of ignorance and the illumination of knowledge. Please join me in welcoming Director Sir, Head of Departments, speakers, and Professor in charges to the stage for this auspicious beginning.
As light dispels darkness, the lamp lighting symbolizes the illumination of knowledge, wisdom, and understanding that we seek through this event. This ceremony signifies the beginning of a journey towards enlightenment, where we gather to learn, grow, and inspire each other. The flickering flames reminds us of the perseverance and dedication required to pursue our goals and find our inner light.
May the lighting of this lamp be auspicious and bring forth good results.
May the light of knowledge shine brightly in my heart forever.
May the lamp of knowledge turn brightly in the hearts of all people.
May the knowledge be supreme and all darkness be dispelled.
Thank you, sir. Now, I would like to request HOD sir, Dr. Anu Chaudhary, to come up and say a few words.
Thank you, Bede, for giving me the opportunity to welcome the participants for this one-day workshop. I extend my warm welcome to our director, Dr. Hemant Ahuja, all head of the departments, all the participants joining us for this one-day workshop on intellectual property right. It is organized by CSC department and the workshop is sponsored by UPCST. Heartfelt thank is to our speakers for graciously sharing their expertise despite of their busy schedule, and your contribution will be actually useful for all the participants. I am delighted to announce that the workshop will be live streamed on YouTube, so that we'll be able to cover maximum crowd and the participations will also be increased. So this whole workshop will be available on YouTube. The link will be shared soon so that you can also refer that. Before we talk about, we'll invite our speakers. I just want to tell you about the theme of the workshop. The theme of the workshop is very useful actually for all the scholars. You're already aware that the theme is IPR, and IPR is playing a very important role for safeguarding our innovations, ideas, and trademarks. So I am very much hopeful that the important information which our speakers will be sharing will be actually useful for all of us. Because if we want to publish anything, it is very much mandatory for all of us to ensure that our innovation is safeguarded. Our patent is already maintaining its own secrecy. So I'm very much hopeful that the important information which our speakers will be sharing to all of us will actually be useful. I extend my best wishes to all the participants for fruitful and enlightening workshop. Let make the most of opportunity of our workshop will be very much useful and will be able to publish more patents and will also be able to ensure that our research work is always related to us only and it is not misused somewhere. So all the best wishes to all the participants and I'm hopeful that this 4 to 5 sessions will actually be useful for all of us and we'll be able to publish more. We have tried to include some students as well because being a educational fraternity, our students are very good, valuable resources for us. And I'm hopeful that they'll also be able to understand the depth of this particular activity of sharing our information and publishing the information on the internet for your intellectual property rights. So thank you so much.
Thank you, sir.
Today's event is based on intellectual property rights, as every individual should be aware of what it basically means. Intellectual property rights are legal rights that gives creator or inventor exclusive control over their creation for a certain period. These creations can be inventions and creative works.
These rights allow creators to control how their work is used, profit from their work, and receive recognition for their work. The main types of intellectual property rights are patents, copyrights, trademarks, and trade secrets. As we navigate the increasingly innovative landscape of our world, understanding intellectual property rights is essential.
Now, I would request Director Sir Dr. Hemant Ahuja to kindly welcome Mr. Roshan Agarwal with a sapling.
Now, I would like to request Dr. S.L. Kapoor, Dean First Year, to welcome Mr. Devesh Agarwal with sapling.
It is now my distinct honor to invite to the stage our very first speaker, Mr. Roshan Agarwal, CEO, Siddharth Intellectual Property Innovation Private Limited, New Delhi, and General Secretary, Swadeshi Science Movement of India. With his vast knowledge in the field of intellectual property rights, IP and software valuation, Roshan Agarwal founded Siddharth IP Company in 2005. A postgraduate diploma holder from the Indian Law Institute, Delhi, he attended the summer school on intellectual property at World Intellectual Property Organization held at Geneva in July 2006. His vast knowledge in his discipline has helped Siddharth IP in emerging as one of the leading companies providing database searching services, valuation on softwares, intellectual properties. Mr. Agarwal holds advanced certification and his association with the National Intellectual Property Organization has also embarked on his career when he was elected to be the representative of NIPO as an observer of the assembly meeting in 2008 at WIPO Geneva. His credibility does not end here. He is also a degree holder in information technology and a bachelor of law, which has enabled him to understand the importance of innovation. Understanding the need, he now works as capacity building of intellectual property and innovation management in India for NIPO. Mr. Agarwal has been associated with the True Value Concept and ARC Associates for the last 10 years. Now I request Mr. Roshan Agarwal to come up on the stage to share his valuable insights with us.
फोन में आता है, उसकी जो रॉ कॉस्टिंग होगी, रॉ कॉस्टिंग जैसे उसकी डिजाइन की कॉस्टिंग है या उसकी क्या कहते हैं आपके प्लास्टिक की कॉस्टिंग है या, तो वो इतनी ही कॉस्टिंग होगी, ठीक है। लेकिन फिर भी वो वर्थ कितना ले रहा, 1,24,000। तो यही आ जाता है इंडस्ट्रियल प्रॉपर्टी में, पैसा बनाना है भैया। क्या बनाना है? पैसा, मनी। इंटेलेक्चुअल प्रॉपर्टी इज डायरेक्टली प्रोपोर्शनल टू मनी, ठीक है। तो वी हैव टू मेक द मनी, ठीक है। तो अब क्या आता है कि जो इंडस्ट्रियल प्रॉपर्टी होती है, एक तो हमने कॉपीराइट देख रहा है, जो वी यूज टू हैव अ मूवी, सॉन्ग्स एंड ऑल दैट। इन इंडस्ट्रियल प्रॉपर्टी वी कॉल इट, किसी ने कहा कि सब आइडियाज या इनोवेशन या पेटेंट्स, ठीक है। तो एक होता है उसमें पेटेंट, एक पार्ट होता है, दूसरा पार्ट होता है उसमें कॉपीराइट, तीसरा पार्ट एक सर ने बोला सेमीकंडक्टर डिजाइन सर्किट, ओके। तो ये हमारा इंडस्ट्रियल प्रॉपर्टीज के पार्ट होते हैं। कुछ पार्ट होते हैं, कुछ इंटेलेक्चुअल प्रॉपर्टी के पार्ट होते हैं कि वो प्रोटेक्शन देते हैं, जैसे ट्रेडिशनल नॉलेज और ज्योग्राफिकल इंडिकेशन वी विल ऑल्सो कवर। होता क्या है कि किसी ने बोला था कि बासमती या हल्दी को पेटेंट करा लिया गया था। किसने बोला था सर? क्या नाम है सर आपका? कौन सी ब्रांच है सर आपकी? कंप्यूटर साइंस फाइनल है। तो सर का नॉलेज बहुत अच्छा है। उन्होंने कहा कि सब बासमती या उस हल्दी के या नीम के रिलेटेड पेटेंट हुआ था, ठीक है। तो वो यूएस में किसी कंपनी ने कराया था, ओके। तो प्रॉब्लम पर्पस क्या है कि भारत में इस ट्रेडिशनल नॉलेज का या स्वदेशी साइंसेस का बहुत पहले से उपयोग चला आ रहा है, ठीक है। नीम एग्रीकल्चर में भी इस्तेमाल होती है, धीरे धीरे हमारे दवाई वगैरह में भी इस्तेमाल होती है, तो बहुत पहले से चला आ रहा है, ओके। अब इतने पहले से ये चीज चली आ रही है, उसके बाद कोई आया भारत में घूमने, होता क्या है, जैसे पहले अंग्रेजों के जमाने में होता क्या था, अभी भी चलता है, आए भारत में घूमने, हाँ गए आगरा की मार्केट, यहाँ की मार्केट, वहाँ की मार्केट, ये कैसे बन रहा है, ये कैसे बन रहा है, ये किसकी टेक्नोलॉजी है, ठीक है। एक वो मूंगफली बेचने वाले का गाना फेमस हुआ था अभी, कच्चा बादाम, ठीक है, ठीक है, कच्चा बादाम, ठीक है। तो अब इंसान आता है देखता है कि यार ये कच्चा बादाम बेच रहा है, बढ़िया गाना है, इसका रॉक स्टार म्यूजिक बढ़िया है, ठीक है। तो जाते हैं, कहते हैं यार हम चलो, उनके पास सब इंस्ट्रूमेंट है, इसके पास साइकिल वाले के पास क्या है, चलो हम बजाते हैं, और उसने उन्हें फेमस कर दिया, ठीक है। तो अब तो एक गवर्नमेंट्स या जो सब लोग मिले आपस में, एक लॉबिंग एजेंट है, इंटरनेशनल सोसाइटी है, वो सब बोलते हैं वाइपो, वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन, ये यूएन की बॉडी है। तो उन लोगों ने कहा कि एक ट्रेडिशनल नॉलेज को प्रोटेक्शन का भी एक तरीका स्यू जनरस सिस्टम होना चाहिए, जिसमें गवर्नमेंट कहे कि साहब ये ट्रेडिशनल नॉलेज हमारी है, या हमारा फोल्क हमारा डांस हमारा है, ओके। तो एक हमारा सिस्टम हो गया ट्रेडिशनल नॉलेज को प्रोटेक्ट करने का। तो भारत में एक ट्रेडिशनल नॉलेज डिजिटल लाइब्रेरी भी बनाई गई उसी इंसिडेंट के बाद, ओके, और उसको प्रोटेक्शन के लिए इस्तेमाल होती है। अब इसी बीच में एक और चीज बताता हूं, होता क्या है कि जब हम किसी को पेटेंट देते हैं, कोई किसी ने नया आविष्कार किया, तो उसे हम प्रोटेक्ट करते हैं। नए आविष्कार को क्यों प्रोटेक्ट करते हैं? अगर उसकी इंडस्ट्रियल एप्लीकेबिलिटी है, कि उसने एकदम धंधे पे नहीं लगा, उसने पेशेंस करा, 5 साल तक पेशेंसली वो एक जगह काम कर रहा है, ठीक है। तो उसे उसकी वर्थ का हिस्सा देने के लिए उसे हम लोग एक आईपी कंपोनेंट उसमें होना चाहिए। जैसे सोना तो सभी बेच रहे, लेकिन S24 लिमिटेड ही लोग बेच रहे, उसकी टेक्नोलॉजी में उसने रिसर्च करी होगी, पैसे लगाए होंगे, 10 फोन तोड़े होंगे, तब जाके वो बना पा रहा है, एडवर्टाइजमेंट कर रहा है, चीजें कर रहा है, कुछ भी टेक्नोलॉजी लगाई होगी, तो उसने समय लगाया। तो उस समय को और उसके दिमाग को प्रोत्साहित करने के लिए वी गिव द राइट फॉर पेटेंट, ओके। अब वो राइट कैसे दिए जाते हैं, वो ये देखे जाते हैं कि ये पहले से तो कोई किसी ने नहीं बना रखा, तो इसलिए हम लोग इसमें पूरा आईटी आ जाता है, जुड़ जाता है। अब पहले तो नहीं बना रखा है, तो भारत सरकार अगर किसी को पेटेंट ग्रांट करती है, तो उससे पहले ये चेक करेगी कि ये पहले कहीं पब्लिश तो नहीं है रिसर्च जर्नल्स में या कहीं पे भी। तो उसमें पूरा आईटी का रोल आ जाता है, एआई का रोल आ जाता है कि भैया वो सॉफ्टवेयर है, डेटाबेस में डाटा एंटर करना है, चेक करना है, पूरे वर्ल्ड में सर्च करना है, सर्च इंजन बिल्ड करने हैं, तो द रोल प्लेस। तो अब उसी को देखने के लिए कि किसी को ऐसा पेटेंट ना मिल जाए नीम हल्दी का कि वो किसी की ट्रेडिशनल नॉलेज का पार्ट था, तो इसलिए भारत में एक लाइब्रेरी बिल्ड करी गई, ट्रेडिशनल नॉलेज डिजिटल लाइब्रेरी, TKDL बोलते हैं उसे, ट्रेडिशनल नॉलेज डिजिटल लाइब्रेरी। ठीक है, तो पहले से जो पहले पब्लिक डोमेन में है उसे चेक करने की भी जिम्मेदारी भारत सरकार की है, तभी वो पेटेंट ग्रांट करेगा। ठीक है, तो उसे बोलते हैं पेटेंट। ओके, सो दिस इज वन ऑफ द पॉइंट। इसी तरीके से ट्रेडमार्क जो है, ट्रेडमार्क होते हैं ब्रांड नेम, तो वो भी पहले से चेक होगा कि पहले से तो नहीं है ये, हाँ लोगो। ओके, अब आ जाता है एक और पॉइंट आपका रहता है ज्योग्राफिकल इंडिकेशन। तो ज्योग्राफिकल इंडिकेशन क्या है कि अब देखो भारत के कोई ज्योग्राफिकल इंडिकेशन के कोई नाम बताएगा? और अच्छा, फ्रांस का ज्योग्राफिकल इंडिकेशन, हाँ वाइन, किसने बताया? फ्रेंच वाइन। ठीक है, तो ये क्या है कि ये भी एक मतलब सरकारों को लगा कि ऐसा ना हो कि कोई उन्हीं को अपना ब्रांड नेम रजिस्टर्ड करा ले। जैसे बासमती है, वो एक ज्योग्राफिकल इंडिकेशन है भारत और पाकिस्तान के लिए। विश्व में चाइना बासमती नाम से चावल यूरोप में नहीं बेच सकता। इट इज नेम इज प्रोटेक्टेड फॉर अ ज्योग्राफिकल इंडिकेशन फॉर 2 countries of South Asia, that is India as well as Pakistan. ओके, तो चाइना है या मलेशिया है तो ये बासमती राइस मार्केट में नहीं बेच सकते। मतलब राइस तो बेच सकते हैं, बासमती कह के नहीं बेच सकते। और हो सकता है कि वो बासमती हो, मतलब ये सब धंधा है। मतलब आपकी वाराणसी साड़ी है तो ट्रेडिंग है, ये हो सकता है कि वाराणसी साड़ी इतना प्रोड्यूस नहीं कर सके, लेकिन ब्रांड इतना बढ़ गया तो जिनने उधर का ज्योग्राफिकल इंडिकेशन साड़ी वाले वाराणसी वालों ने लिया हो तो वो सूरत से साड़ी मंगा के उसमें वाराणसी साड़ी का टैग लगा के ले भाई ले। मतलब द थिंग इज दैट कि ऐसा भी हो रहा है, लेकिन इसे प्रिवेंट करने के लिए उन्होंने कहा ज्योग्राफिकल इंडिकेशन है, होना नहीं चाहिए, लेकिन स्टिल इट इज अ गेम ऑफ बिजनेस। अभी G20 समिट हुआ था तो एक सब राज्याध्यक्षों को वो दिया गया था एक, हाँ, चावल टाइप का। ठीक है, तो वो भी एक GI आइटम था। ओके, सो इट इज नथिंग बट टू हैव अ लोकल बिजनेस पोटेंशियल टू कम अप, लो लोकल। ओके, so this is geographical indication. So you all are now aware of patents, copyrights, geographical indication, traditional knowledge, trademark. Okay, so one thing is now left, industrial design. यहाँ सर
क्या सोशल बिहेवियर को भी पेटेंट किया, कॉपीराइट किया जा सकता है?
सर मेरे ख्याल से तो नहीं किया जा सकता। क्या कॉपी, हाँ हाँ, क्या है सर ने, हाँ
नमस्ते,
हाँ हाँ
हाथ मिला के करता है,
हाँ हाँ
बाय बाय करता है,
हाँ हाँ सर, क्या मैं बता रहा हूँ सर, देखो नाइस क्वेश्चन के सर ने कहा कि सोशल बिहेवियर को कॉपीराइट क्या होता है सर। राइट जो है ना, मैंने कहा सर ये मनी से रिलेटेड है। ये दो फंडे होते हैं क्या कि जैसे जो प्रोफेसर्स वगैरह जो मतलब प्रोफेसर्स होते हैं, ठीक है, तो वो लोग पब्लिकेशंस पे ध्यान देते हैं। ठीक है, IP इज नॉट काइंड ऑफ पब्लिकेशन। ठीक है, अब कॉपीराइट, आपने कहा कॉपीराइट, अब उससे आप मनी कैसे जनरेट कर रहे हो सोशल बिहेवियर से? अगर आप मनी जनरेट करोगे,
नहीं जी मैं बताता हूँ, जैसे कि मैं हमारे नॉर्थ इंडिया में है कि हम नमस्ते करते हैं।
हाँ हाँ,
अब हम जो भी हिंदुस्तान में कहीं वर्ड में नमस्ते करेगा
हाँ,
वो हमसे पूछ के करेगा।
नहीं तो वही तो कह रहा, आप क्या ये राइट आपको कौन दे रहा, कौन प्रोटेक्ट कर रहा?
मांगना चाहते हैं, क्या
नहीं
ले सकते हैं?
नहीं नहीं नहीं, तो वही तो कह रहा, अगर भारत सरकार आपको राइट दे या US सरकार, नहीं नहीं, अभी कोई भी चीज राइट्स ऐसे हैं जो अगर मिल सकते हैं तो वो प्रोटेक्ट है।
ये कौन डिसाइड करेगा कि राइट कौन से मिल सकते हैं, कौन से नहीं मिल सकते?
वही तो मैं कह रहा हूँ, उसके लिए क्या होता है कि जैसे सरकार है तो सरकार के रिस्पेक्ट में एक उनने संस्था बना रखी यूनाइटेड नेशन, उसके रिस्पेक्ट में उन्होंने लॉबिंग ऑर्गेनाइजेशन बना रखी वाइपो, वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन। वहां पे यहाँ के सेक्रेटरीज वगैरह जाके लॉबी करते हैं या बड़े बड़े बिजनेसमैन लॉबी करते हैं, ठीक है, ऐसा होना चाहिए, ऐसा, फिर सरकार उसे राइट देती है। अब सरकार हर एक को, पुलिस को थोड़ी पकड़वाएगी कि साहब ये चीज आपकी है। तो इसलिए जो भी कॉपीराइट होगा वो आपका एक्सप्रेशन होगा, आपकी बुक्स जो रिप्रोड्यूस हो रही हैं, जैसे आप रिप्रोड्यूस, आपके सॉन्ग्स हैं, आप रिप्रोड्यूस कर पा रहे हो उस चीज को, तो और उस रिप्रोडक्शन को आप रोक सकते हो, इतने आपके पास हक हैं, पावर है कि आप उस रिप्रोडक्शन को रोक पाओ, तो वो राइट में कन्वर्ट हो जाएगा।
जैसे आपने एग्जांपल दिया था, एक पिक्चर बनाई,
हाँ,
उस थीम को लेके पिक्चर पब्लिश कर दी,
हाँ, तो वो हाँ, अब वही एग्जांपल मैं बताना चाह रहा था कि वो जो थीम है वो राइट कॉपीराइटेबल नहीं है, सपने कॉपीराइटेबल नहीं है। हमने रात में सपना देखा, जब तक कि देख लिया वो खत्म, वो कॉपीराइटेबल नहीं है, जब तक कि हम उसे एक्सप्रेस, मूवी कॉपीराइटेबल है। कॉपीराइटेबल ऐसी कि उसकी कॉपी नहीं होगी, पुराने जमाने में कैसेटें चलती थी कि हम कॉपी पेस्ट उसे ना कर सके, उस जैसी दूसरी बना लेंगे तो वो मान्य है। हम आए, हमने वही डायलॉग फिर से बोल दिए, दूसरे ने रिकॉर्ड कर लिया, तो वो मान्य है, उसमें थोड़े से रिकॉर्ड्स वगैरह चेंज कर दिए तो वो मान्य है। जैसे आपने एक जावा का प्रोग्राम लिखा, ओके, किसी ने जावा का प्रोग्राम लिखा, तो उस जावा के प्रोग्राम में एक ने और लिखा और दूसरे, और किसी ने उसको कॉपी कर लिया, और किसी ने लेट ए इक्वल टू बी प्लस सी लिखा, किसी ने लिख दिया लेट डी इक्वल टू ई प्लस एफ। ओके, कंसेप्ट वही रखा लेकिन वेरिएबल वगैरह चेंज कर दिए, तो वो कॉपीराइट नहीं है। दोनों में बहुत अंतर है। हाँ सर, पता है। सोशल बिहेवियर ज्योग्राफिकल फॉल्ट फॉर डांस में आएगा, अगर कोई वो उसे प्रोटेक्ट कर रहा है तो। बताएं सर। हाँ, तो आएगा, मनी जनरेट कर सकते हैं और उसे प्रिवेंट कर सकते हैं दूसरे को रोकने के लिए, इतनी पावर होनी चाहिए, तो आ जाएगा कि अपन दूसरे को प्रिवेंट कर लें। भैया सरकार के पास इतनी पावर हो, शक्तियां हो कि उससे मना करे, भाई तुम नमस्ते नहीं करना,
नमस्ते करे तो फाइन,
हाँ, तो वही तो कह रहे, पेनाल्टी हो। ओके, यस, हाँ, प्लीज कीप क्वाइट सर। ओके, प्लीज लिसन टू, व्हाट इज योर गुड नेम? हाँ, प्लीज लिसन टू मिस्टर विकास। हाँ, 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 नहीं, तो पेटेंट की बात नहीं हो रही इधर सर ने। कॉपीराइट बहुत सारे राइट्स होते हैं, पेटेंट एक अलग राइट है। That condition is only in patent, not in copyright, not in industrial design, only in patent, not in GI. हाँ, आप जो बात कर रहे हो वो पेटेंट से रिलेटेड सही कर रहे हो। हाँ, आप जो बात कर रहे हो वो पेटेंट से रिलेटेड कर रहे हो। सर का एक जनरल क्वेश्चन था IPR से रिलेटेड, सही कह रहा हूं सर? ओके, सो व्हाट अ पेटेंट इज एन एक्सक्लूसिव राइट फॉर एन इन्वेंशन। क्या बोल रहा सर? ओके, okay, no issue. So it is trademark, copyright. Okay, then we have an industrial design. Okay, so industrial design basically like this is the pot. Okay, so this is one of the design. Okay, जो outer aesthetic feature को denote करता है, that is called a industrial design. Like we have a glass. ठीक है, तो ग्लास है और कैन हैव मल्टीपल शेप्स। ओके, इसमें क्या है कि वो ग्लास के दो तरीके के काम होते हैं, एक होता है पानी को होल्ड करना, ठीक है, एक होता गिलास खुद होल्ड हो जाए, और एक होता है कि उसे अपीलिंग, आपकी आंखों की अपीलिंग डिफरेंट हो। ठीक है, तो जो पानी में वो होल्ड कर रहा है, पानी को जो होल्ड कर रहा है वो है उसका यूजेज। ठीक है, यानी यूजेबिलिटी। ठीक है, आप उसे होल्ड कर पा रहे हो, ये भी उसकी यूजेबिलिटी है। लेकिन जो आंखों से जो अपील हो रहा है वो उसकी यूजेबिलिटी में नहीं आता है। ओके, तो जो इंडस्ट्रियल डिजाइन होती है वो आंखों की अपीलिंग पे डिपेंड करती है, और जो पेटेंट होता है वो उसकी यूजेबिलिटी पे डिपेंड करता है। जैसे चश्मा है 36 डिजाइनों का होता है, लेकिन यूजेबिलिटी क्या है कि कांच को वो होल्ड करे, तो ये आएगा पेटेंट में। जैसे फोन है, तो फोन में अब आप लोगों से एक क्वेश्चन है कि उसका पेटेंट एक्सपेक्ट क्या है और उसका इंडस्ट्रियल डिजाइन एक्सपेक्ट क्या है फोन का। तो फोन का जो इंडस्ट्रियल डिजाइन एक्सपेक्ट है वो है उसका शेप। ठीक है, अब जो उसका पेटेंट एक्सपेक्ट है वो उसकी स्क्रीन, या पहले कीपैड आते थे, स्क्रीन आते हैं, उसका जो उसमें आपने कैमरा लगाया, फ्रंट कैमरा, रियर हैंड कैमरा, आपके फिंगरप्रिंट रीडर, तो ये जो फंक्शनैलिटीज है ये है पेटेंटेबल एस्पेक्ट्स।
फोन का आपने एग्जांपल लिया,
हाँ,
क्या इसका साइज भी पेटेंट हो जाए, कॉपी कुछ हो सकता है? किसी ने ऐसा साइज, कंफर्टेबल साइज है,
हाँ,
इतना बड़ा साइज बना दिया तो पकड़ने में बड़ा मुश्किल होगा।
बिल्कुल,
इस आदमी ने पहली बार ये इसका डिजाइन बनाया, साइज बनाया,
हाँ, हाँ,
ऐसी पेटेंट।
बिल्कुल 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 सही बोला सर आपने। दैट इज द पेटेंट में बिल्कुल साइज आप क्लेम कर सकते हैं। ओके, तो जब हम लोग पेटेंट देखते हैं तो गूगल पेटेंट इज वन ऑफ द गुड वेबसाइट, ओके, वेयर यू कैन फाइंड योर प्रीवियस ईयर पेटेंट्स। तो पेटेंट में क्या होता है कि नया इनोवेटिव कंसेप्ट तो है ही, और सर ने जो कंसेप्ट बताया है साइज, तो व्हाट वी हैव टू राइट इन द पेटेंट व्हेन वी गिव द एप्लीकेशन टू इंडियन पेटेंट ऑफिस इज वी हैव टू क्लेम द पेटेंट, वी हैव टू राइट द क्लेम्स। क्या क्लेम्स? एंड इन क्लेम वी हैव टू राइट इट कि माय phone design is from 5 inches to 8 inches. Like from 5 inches to 8 inches, no one will prepare any phone.
तो ये रजिस्ट्रेशन दिया जा सकता है?
हाँ, तभी तो प्रिवेंट होगा दूसरा बंदा।
तो सारे फोन तो ज्यादातर इसी डिजाइन के बनते हैं।
हाँ, तो किसी का पेटेंट होगा तभी तो ये महंगा है, 1000 रुपए से ज्यादा की चीज नहीं है उसमें, अपन खरीदते हैं। नहीं सर, वो
सारे टेलीफोन इसी साइज के।
हाँ हाँ, तो ये किसी ने
पेटेंट नहीं हुआ है ना?
नहीं नहीं नहीं, पेटेंट लाइसेंस करे होंगे ना किसी ने। ये आप ये देख रहे हैं जिसके जैसे जो होल्डर्स हैं, जैसे सैमसंग वगैरह पेटेंट होल्डर हैं, तो वो एक ही फैक्ट्रीज में बन रहे हैं, एक ही फैक्ट्री में चीजें बन रही हैं, वहीं पे लार्ज लेवल पे बनते हैं, ब्रांड नेम अलग अलग।
मेरा कहने का मतलब ये है,
हाँ,
सैमसंग का है,
हाँ,
ऐसे कई ब्रांड के टेलीफोन हैं,
हाँ, हाँ,
के नॉर्मली साइज सबके एक सही।
हाँ, हाँ सर, सबके।
एप्पल बनाता हो,
हाँ हाँ, तो जिसने भी लिया होगा तो वो साइज पे पेटेंट लिया होगा।
तो इसका मतलब वो पैसे एक्सचेंज।
हाँ हाँ, फिर अब फ्रेंड राइट्स होते हैं, लाइसेंस अरेंजमेंट होते हैं। टेलीकम्युनिकेशन में एक फ्रेंड टर्म है, ओके, उसमें लाइसेंस अरेंजमेंट्स होते हैं, जिसमें मतलब वो लंबा टॉपिक है सर कि एक दूसरे के बीच में लाइसेंसेस को आदान प्रदान, हम तुम्हारा लाइसेंस इस्तेमाल कर रहे हैं, तुम्हारा पेटेंट तुम हमारा कर लो, बार्टर सिस्टम, तुम्हें हमें पैसे नहीं देना, हम आपको पैसे नहीं दे रहे। व्हाट वी कॉल इट एज ए फ्रेंड टर्म्स। ओके,
पेटेंट में कुछ चीजें एंड करके भी हो सकती है ना।
हाँ
जैसे सर बोल रहे हैं कि साइज,
हाँ, हाँ वो होते हैं,
साइज सारे हैं, बट
हाँ,
एंड करके वो कंडीशन अप्लाई होती है।
हाँ 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 हाँ।
साइज तो एक हो सकता है।
मैम एक नेक्स्ट प्रेजेंटेशन हो रहा है मेरी ना इसमें। हाउ मच टाइम आई हैव? सुनो मैम, क्या टाइम हो गया? क्या है सर, कोई है कि उसके बाद किसका है सर? हो गया सर, टाइम हो गया। थैंक यू सर। सो थैंक यू वेरी मच फॉर गिविंग मी द टाइम। और अगर मुझसे कोई गलती हुई तो माफ, ठीक है सर, ओके सर। तो आईपी इज ऑल अबाउट मनी, मनी जनरेशन। आईपी के संग में एक फायदा ये है कि हो सकता है कि बड़े बड़े अमीर लोग हैं जिनके पास जमीन है, जायदाद है, लेकिन आप लोग भी S24 जैसे प्रोडक्ट बना के अच्छा रेवेन्यू कमा सकते हो। ठीक है, तो आईपी के माध्यम से मनी कैन बी क्रिएटेड, और ये हमें मलाल नहीं होना चाहिए कि हम इनके पास इतना है, उनके पास उतना है। आज की युग में एनीथिंग कैन बी अचीव्ड।
इसके प्रोसेस के बारे में भी जानकारी होनी चाहिए लोगों को।
हाँ हाँ, तो सर वो
बहुत जरूरी है।
हाँ वो लंबा,
आइडिया तो बहुत है, पर हम लोग जानते नहीं कैसे करना है, इसलिए करा नहीं पाते।
हाँ तो वही, that is the objective of this, my I think so, this this session.
First complete workshop on the filing of
Thank you, sir, for sharing your knowledge with us. Now, I would like to call HOD Sir Dr. Anu Chaudhary for presenting a gift to Mr. Roshan Agarwal as a token of thanks.
Now I request all the guests to proceed for the high tea. The event will continue at 11 a.m.
Hello, hello, hello.
Hello, hello, hello. 1 2 3 check. Hello 1 2 3. Hello 1 2 3. इसमें ज़्यादा ले रहा. Hello 1 2 3. Hello. Irrigation.
ये मैं फोन कर रहा तुम्हें फोन कॉल उठा रही अभी उसी टाइम पे 3-4 मिस कॉल है मैं बैटरी डिस्प्ले करा था वो देख रहा था इसी का बीच में वो लगा देता
Right.
Respected audience, the speakers has arrived. We will about to start in a few minutes.
Welcome back, everyone. I hope you enjoyed the refreshing tea break. Let's dive back into the topic intellectual property rights. I request Dr. BK Sharma, HOD Mechanical, to welcome Mr. Gaurav Gupta with a sapling. Thank you, sir.
Now, we have our second speaker, Mr. Gaurav Gupta, Manager, Sienna Corporation, Gurgaon, patent professional expertise in drafting and prosecuting US, EP, and IN patent applications. He is a patent professional with 10 plus years of experience and expertise in drafting and prosecuting US, EP, and IN patent applications. Helps corporates and tech giants to build their patent portfolio. He has represented a wide variety of clients ranging from large Fortune 500 companies such as Google, Verizon, Sony, Motorola, and Johnson Controls. He prepared and prosecuted a wide variety of technologies, including AIML, power electronics, power systems, computer technologies, wearable computing devices, automotive battery systems, and many more. I request Mr. Gaurav Gupta to come up on the stage.
Thank you, everyone. And once again, thank you again for having this session. And am I audible without this mic?
It's fine. Hello. So, I've been working as a patent professional for last 10 plus years. And what is a patent? So, there is a big buzz these days about patents. What do we do? And what is actually a patent? What thing can be patented? What cannot be patented? So, this is a common buzz these days. And if you read about the news, then Make in India thing and the Digital India thing. So now every startup which is coming these days, so they want their technology to get patented. Why? So why they need a patent for their technology? So the reason is that the protection, your intellectual property Means anything which is in your brain is getting protected by a patent. Patent is a certificate which you get once you apply for it, and it gets approved by this Indian Patent Office. So there is a mechanism for it. First we apply, and then it gets examined, and then the patent gets issued. So there is a proper mechanism for all this thing, and it will be a full day session to introduce you to this full concept. But let me start with something basic. So any idea about what invention can be patented? Any idea in mind what invention can be patented? So there are three things for any invention to be classified or to be eligible for getting a patent. So the first thing is that your idea must be novel. So talking about the novelty, the fact about novelty is that your idea should not be in practice, or it must not be disclosed before you are applying for it. So the first and the most important critical aspect in applying for a patent is its novelty. If it is novel or not. If it is novel, then yes, we can apply for a patent. If this is not novel, then it will not be qualified for getting a patent. Now, what do we mean by novelty? What is novelty? So anything and everything which is known to a common person comes under the category of being novelty. So if I am applying for a patent, if I am applying a patent for this mic, then examiner will search for it that whether this technology of receiving this voice signal and converting into electrical signal, and then we have a speaker somewhere. So it is converting again that electrical signal to voice. So this technology, examiner will search for it. The government will search for it, whether this already exists or not. So after searching for it, if it comes that it is already available in public domain, then it will not be considered as a novel aspect. If this technology was not covered, was not available to the public, and it is not covered in the public domain, then it will be considered as a novel aspect. So this is the first criteria. And what is a common knowledge, and what is we mean by public domain? Means what knowledge is in public domain? Anything and everything which is available. A YouTube video can be considered as a prior art to kill the novelty of invention. Any blog, any LinkedIn post, it will be considered, anything which is available to public, it will be considered as a prior art for your invention. So this is the first aspect of novelty. And then comes the inventive. Whether your invention, whether your idea is inventive or not. So we talked about novelty, that it is not being disclosed earlier. Now there is one more criteria of inventive step. So what is this inventive aspect? So let us consider I am applying for a patent for any invention like my pen, and I have put an umbrella over that pen. So does this make any sense that I am putting an umbrella over my pen? So it doesn't. It doesn't make any sense, and it doesn't make any inventive. It doesn't make any inventive aspect. It doesn't make any technical contribution. So it is not contributing technically to any means your technology. So these things will not be considered inventive. So if I am talking about the inventive aspect of your invention, then it means that it should solve some problem, existing problem. So your idea should be solving some problem. So this is the another thing about the inventive aspect. So we talked about novelty, we talked about inventive aspect. The third criteria is the industrial applicability. If you are making any product, if you are making any technology, and it doesn't make any sense, it doesn't contribute to the industry, and it doesn't have any application, then it will be denied for a patent. So these are the three basic criteria of getting a patent. So now we have discussed that what is a patent and how do we get it and what are the criteria. Let's talk about some facts. A patent is a certificate. It is a negative right given to the inventor, given to the person who is applying for it. It's a negative right that no one other than you can use this technology. No one other than you can use this technology. But on the same time, the government asked the inventor to disclose all the information about the patent to public. These are two contradictory things in patents. First, government is giving you exclusive right. If I'm saying exclusive, it means only you can use it, and it is excluding others from using this technology. But on the same hand, on the same time, the applicant is bound to disclose the technology so that after this patent gets expired, it will be available to public. So this is for the benefit of the society that the applicant, the inventor should disclose this to the public, to the society. It is for the benefit of the society. But since the inventors have contributed much and it is their effort, therefore government gives them certain time period. For that time period, only you can use it, no one else can use it. So that time period is 20 years in India. Generally, it is 20 years all over the world. Means 1 or 2 year differences there in some jurisdictions. But a common time frame is generally 20 years. So, patent are the exclusive rights and these are the negative rights. There are some rights which considered a positive, but this is a negative right, and it is given for a fixed time period of 20 years only. So there are common myths about patents. So I don't know if all of you are from computer science background or there are mix of electronics, electrical, mix of electronics and electrical. So yes, so there is a common myth about patents is that softwares cannot be patented. There is a common myth around in the industry that softwares cannot be patented. And since you are CSE computer science students and these days you must be using AI and ML in your the final year projects, right? So I suggest you to if you are creating a buzz and you are creating some novel algorithm or anything which you think that it is not being done till now, I'll suggest you to apply for a patent for this. It will take time, but it will help you in your growth. And this is patents are very the most valuable things right now. And every startup is going for the patents. The reason is that it creates your value. It displays that how worthy your technology is. If you have means 100 patents for your product, then it will definitely reflect that how novel, how new, how problem solving your technology is. So, but for the software thing, there is a common myth that softwares cannot be patented. Coming to that, it's not. So softwares can be patented, but there are some regulations, there are some criteria for applying a patent based on some software inventions. So I will suggest means these computer science students to not refrain from applying for a patent in case you have any idea. So let's come again to our topic that why patent is valuable. The first thing is you are getting protection for your technology. The second thing is money. You can monetize your patent. You can sell your technology. you can give license of your technology to some of the users. So this is the second aspect that patents are valuable. And the another aspect is that the social service, that if you are giving some of your exclusive technology to public domain after 20 years, you are doing some social service and it's good for the society. So these are some benefits of applying for a patent. And the most valuable thing about patent is the monetization part. You can monetize it very quickly. So billions of dollars are dealt with these patents, and if you see that Apple is getting sued for its products, its designs by Microsoft, by Samsung, by Motorola. So because if you see Elon Musk recently alleged that I do not apply for a patent, weak people apply for a patent. So the reason is that who doesn't want to disclose his technology, wants to hide his technology, they don't apply for a patent. And who don't want to monetize their technology, they don't apply for a patent. But whenever you want to monetize, whenever you want to sell your technology, so it's always suggested to apply for a patent. So in industries these days, you just talk about the name and you will find that there must be hundreds of patents in the name of that company. Okay. So the next thing. So the next part about these patents is that if we come to Indian patent law, see, the patents are jurisdiction based. This is not the fact that if I am applying for a patent in India, it will be covered all over the world. So it's not. If I am applying for a patent in India, I will get protection for Indian jurisdiction only, not for the entire world. So if I talk about the Indian patent laws, so there is an Indian Patent Act 1970 by which all these laws are, by which all these patenting systems is governed, and that law doesn't say that what inventions are patentable. It says in another way around. It says what inventions are not patentable. So let's have some view about what inventions are not patentable. So the first thing is that any mathematical formula, any mathematical algorithm is not patentable. Why? Why it is not patentable? So the reason is that it can be computed in human mind. It doesn't need any special hardware, doesn't need any special processor to compute this thing. It can be done using human mind. So this is the reason why mathematical formulas, all these, if I say Newton's first law, it cannot be patented. If you invent any formula, it cannot be patented. So there are formulas being invented every day. If you are aware of the neural networks, then there is one term in neural network is reward function. Are you aware of this thing, reward function in neural networks? So reward function is something linked to some mathematics, that what feedback you are giving to train any neural network. So there is a mathematical formula, and this cannot be patented because it can be done using human mind. Now, let's come to another thing which cannot be patented is the business methods. There is a very common case law in our industry is that there is one company named Alice, and there was another company named I think Microsoft. I'm not sure about it, but yes, Alice versus Microsoft. So it was the case. What Alice patented is that you do transactions, right? I'm transferring some money to you. Then what's the way of transferring this money? I send a request to my bank, and then bank approves it, and it goes credited into the receiver's account. So this is the payment process which we are following traditionally. But 20 years back, it was not done this way. It was done, it might have been done using electronic means, but not by this way, that is a third party authenticator into it. But conventionally, this has been done like this only. So Alice was granted a patent for this. And you see that this way is very conventional. This way is very, it is abstract. And if someone is, let us say Alice is granted a patent for this technology, like Visa, MasterCard, what are they doing? They are authenticating your payment, right? Visa, MasterCard, RuPay, all these, what are these things? These are payment gateways. And these are just for authenticating your payment. And if someone gets a patent for this technology, then he can sue all these payment gateways, Visa, MasterCard, and RuPay. All these payment gateways are infringing the rights of that patent holder. So that patent was dismissed and it was invalidated. And after this thing, it came to the law that business methods will not get patented. Business method will not get patented. There is, for example, I have an idea of, I go to Amazon and search for some product. And then after some time, I log into my Facebook account and I see the same ads coming over Facebook. Long time back, I was doing one case and it was giving the same result. Means it was trying to claim the similar thing, that if I go to one social platform and I search for something and then I go to another social platform, that recommendation will come whatever my activity was during whole day. So that recommendation will come into the another social platform. So the inventor was trying to protect this thing, and it was broad. And in the case of my, like I said in Amazon and Facebook, it was narrow, that only the product will be shown into my Facebook account. But the examiner said, no, it will not be granted a patent, because this is a conventional way of giving you some recommendations. So this is a business method. So business methods are not protected. So these are two things. First was a mathematical formula. Second is a business method. And the third one is if I say broad categories. So the third one is the mental act, means anything and everything which can be performed in human mind. So this is also not eligible for getting a patent. So let me give you one example. So I have a cattle farm and I have hundreds of animals over there, cows, buffaloes, and what I do is I measure temperature of each and every animal daily, and then I feed them food accordingly, right? For example, if the temperature of any herd gets increased, then I give some 500 mg paracetamol, like this thing. So this thing is, is the way which we are doing using our human mind. There is no machine needed for it. Can I apply a patent for it? Can I apply a patent for it that I am using some machinery to automatically measure this temperature or some other blood reports like this, and I am measuring some biological parameters of that animal, and then based on that some biological parameters I am feeding them. So if I am using machinery for this, if I am automating this task, can this be patented? No, this cannot be patented, because it's a process of human mind. We are doing it conventionally using our brain for a long time back. So these are the three broad categories which cannot be patented. There are many other things, but of course, means there is no point in getting into the laws. So if I talk about the broad categories, then anything and everything which can be performed using human mind cannot be patented. Any business method, and the third one is all those mathematical relations and formulas. So this is about what cannot be patented. Now the question is, what can be patented? So we have set A, which is non-parentable, and there is some universal, there must be some universal set having all your ideas. So everything which is not covered under these three categories are parentable. Now it's up to you to judge whether your idea comes into any of these three categories. If yes, then it will not be patented. If no, then yes, you can go for applying and apply for a patent. So these are this is the basic idea, basic concept of what patent is and how can you use your idea to get it patented. And any question from your side that you have in your mind regarding the patents and the intellectual property. The intellectual property field is very broad. I am covering only patent side of it. So there are trademarks, there are copyrights, GI, Basmati. What is this? This is a GI, right? Because it's a geographical indication of the rice being produced in UP. And Alfonso, we have a GI for it. If anyone is from Lucknow, then that chosa, we have a GI for it. So that mango. So we have GI, we have trademarks, we have copyrights, and patent is one of those segments of this IP field. And I'm open for questions. There must be some queries, there must be some facts which you want to know about patents. Means to final year students, I'm open that if you have some project ideas and how can you apply for a patent, because for students it's very easy in IPO to apply for a patent. There is a minimal fees of 600 rupees and you can apply for a patent.
What's the difference if a software can be patented or a software can be copyrighted?
Yes, very good question. So software, if you talk about the code, it cannot be patented. We can only take copyright for it.
You said that program software can be patented.
Software can be patented, but if it is solving some problem, a code alone.
System is applicable to solve some problem.
But it must be solving some technical problem. See, a code alone cannot solve anything. Code is a sort of literature, and if you apply that code to some processor, and then that processor is doing some task. If it is
some hardware can be included.
Exactly.
Software, then only we can patent the software.
Exactly. If a hardware is implementing that software, then a combination of that hardware and software is eligible for getting a patent. Software alone, that code, it's yes, exactly. Exactly. If you are applying, like, see, I talked about the reward function in a neural network. So if I claim that reward function in my patent, this alone is not eligible for getting a patent. But that reward function is training some neural network, and then that neural network, trained neural network, is applied to some machine. Yes, the whole process or the hardware. So that if that software is implemented in hardware, then it is eligible for getting a patent. Software alone is a term for copyright. So we can apply for copyright for that code. But you see that changing a code a bit and getting the same result is not difficult. So one can easily bypass your code because I can use a different formula for getting the same result, and I can easily bypass your copyright for it, because copyright is for the word to word which you are getting protected. But yes, software can be patented, but not alone. Any other question, please? So
Friend is like innovative entrepreneur and is making some electrical equipment. So I suggested him why you are not patenting it. I think it's all across India. He told that there is some issue in patent because similar type of products are already in the market and there are different patents. But what is being done? One thing what he told that prior use. since I'm using it from earlier and the proof is that I have uploaded one your manual how to use it on YouTube 10 years back. So that is something that will give me support when any case is filed against my company. So I could not understand head and tail what is the meaning.
Okay, okay. So this is a very good question and in depth means anyone who has means analyzing this, so he has in-depth knowledge of what is a process. So this comes under the category of defensive publication. Defensive publication means you are not applying for a patent, but you are making your technology a prior art for everyone else. See, if I have some idea and I don't have money to apply for a patent, what I will do? I should simply make some YouTube video or make some blog and post it on the web. That's it. Then no one else can get a patent for this technology. This is the thing which your friend must be doing. And no one can sue him because he has proof that your patent is it will be a reverse side. So he can invalidate the patent of others because he has already used the technology and invented this technology. Maybe he has not applied for a patent because of some reasons, but exactly. So this comes under category of defensive publication. In our terminology, it comes under defensive publication. Means we are defending, we are defensive, and we are not trying to protect my technology, and rather we are means keeping others from getting it patented. Very good question.
Actually, he had done minor reverse engineering and if there is similar type of products are already in the market, they are big names. If they do against me, of course I would lose. So that's why it's safer side that
Yes, it's safer side to post some YouTube video. If you have some technology, post some YouTube video and it will give you 1 year grace period to apply for a patent. It gives you 1 year grace period to apply for a patent. For example, if I have invented some technology and what I'll do is I'll post some YouTube video or will display in some conference and or publish it in some journal, then still I can apply for a patent. It will not become prior art for me for 1 year. I have 12 months time to apply for a patent for it. It will not become prior art for me. But after 1 year, it will become prior art for me. But we have a time for 1 year. If I have some idea and I get it published in some conference paper, some journal, then still there is a chance of 12 months. There is a grace period of, we say the grace period of 12 months, right? Any other questions? Any other idea which you want to share or you have? We may discuss it. See, means the content is whole day long because the industry, I have around 10 plus years of experience and I have much to say, but again, it comes to your concern that what do you want, what do you expect from me, right? So I can talk whole day long. So if any concern, if any query, if any doubt about, if any myth you have about the patents. So is this the first time you are hearing about the patents or you have some idea about what patent is, what intellectual property is? You have some idea, right? Yes, yes, please. Agent involved करना जरूरी नहीं है. We can file it directly. There is no need to hire some registered patent agents. If you have some idea, go for it, draft an application and file it to Indian Patent Office. It will cost 1,600 rupees only. Because for students, we have some the discount given. For the startups, there is also discount, but for the big firms, there is no discount. We have the proper fees for it. See, in that case, you need to apply for a petition and you have to go to the notary and then write a petition that due to some mistake and due to some unforeseen circumstances, means it was not intentional. And it is only up to the examiner if he allows or not. Because we have 12 months grace period from provisional to non-provisional, and then it is only up to examiner. But there is a way out. You can say it was unintentional. Your intention must not be to extend that 12 months period. That's a fact. So whenever you are applying for a patent, first you apply for a provisional, then don't wait for 12 months. Apply for a non-provisional before that. And even I would say that there is no point in filing any provisional applications. There is no use of it. It is not getting examined. So it is just to claim that priority date, that's it, nothing else. So exactly. So the reason may be funding, that could be unintentional. So that comes under the unintentional part. So your intention must not be to extend this. This should be clear to the examiner, and generally they allows. And for students, they definitely they give freedoms to means for this extension of time period, because of course you don't have this much expertise in this field that after this 12 months it will get expired or not. So yes, he will allow. Go to notary, make some affidavit, and say that, means you have to take an oath that it was not intentional, the delay was not intentional, and I am submitting this non-provisional application herewith, and please consider. So this is the format, and every notary knows it. So you can apply for an affidavit, and yes, please. Yes.
What is the, how is the content, where to do that?
Hmm. Okay. Yes. So applying for a patent. So this is a process. If you Google this thing, Indian Patent Office, and it will give you, the first result will come, that ipindia.nic.in, the website will come, and it has a link for apply a patent. So whenever you apply for a patent, you have to fill form 1. There are different forms. We have to fill a form 1. So form 1 is about the details of the applicant, and then we have the form for the specification, and in that specification you mention all the technological details of your invention, the claims, and then you have to upload the drawings, if any. Generally there are drawings. So, and then you upload it on the website. So it has a portal on it to upload your application, and then it will get filed after applying for after you pay a fees. So fees is nominal 600 rupees, and you can apply for a patent. After you apply for a patent, you will get a receipt that yes, your application is submitted. And after 18 months, you have to apply for the the publication. First you apply for the publication. There is a specified form for it, for making a request to publish your application. So after you file a request for publication of your application, it will get published within, let's say, 1 month or so. There is a time period for it. After it gets published, then again you have to file a request for the examination. So there is a timeline for it. So we have to follow a timeline. Okay. So I'm coming to it. So once you apply for the request for examination, after applying for the examination, your application will go to some controller. So there is a controller. There are many controllers in Indian Patent Office, and they are also the examiners. So when this application go to the controller, he starts judging your application for the first formalities part, whether your application is complete or not. So there are multiple parts of your patent application. So Himanshu will tell you, so we have split it this way. Himanshu will tell you about what are the different parts to complete your patent application. So examiner will judge for all these formalities. Like you said, that it is whether it is being pursued in other jurisdictions or not. So there is a separate form for it. And then you have to fill a form that, Mr. Examiner, my application is being judged in these different jurisdictions. For example, US, EP, Japan. So my application is being judged for these 3 jurisdictions also. So you have to fill a form for it. You have to upload that form into IP India website. And after having judged all these formalities part, then comes the main part of examining your application. What comes under the examination? First, examiner will judge your specification, whether it is complete or not, whether it is any flaw there is in it or not. So if I talk about flaws and if we talk about the specifications, so examiner will judge about all the technical details are sufficient for anyone to practice this invention. It's not that you have claimed something and you have not described it. Means you are taking a protection for it, then it is for the society after 20 years that you should keep this invention in public domain. So you should make your specifications so comprehensive that anyone who wants to practice it can do it easily. And then comes the part of the claims. So examiner will judge your claims, examine your claims for 3 things, which I said in the starting: novelty, inventive step, and the industrial applicability. If examiner finds that all these 3 criteria are met, then he will issue notice of allowance, or the issue to means intent to grant, and based on that intent to grant, we can again have to file a fees to maintain that patent. There is a fees at every stage and there is a form at every stage which we need to file. So we have some time to apply for a means after examiner has issued an intent to grant that your application is ready for getting a patent for it. Then I have to file some fees to maintain that patent. And based on that, I will be issued a patent certificate. And that certificate is not that you have got a certificate and then it's okay, it's for 20 years. No, you have to pay fee every year to maintain that patent. Otherwise, it will get abandoned. It will get lapsed. Yes.
What is the basic profit of a patent? For example, if I'm having a patent on any technique and a big company came and asked for that technique, and if he is using that technique, will he give me the equity, will he give me the share, or some sort of agreement will be between us? What if he don't tell me and use that technique and later on I get to know about it?
Okay. So the point which I mentioned in the starting, that why do we apply for a patent? Monetization. So the main focus these days is to monetize your patent. It's not that you are protecting your technology only, you are intending your technology to pay you money in return. So you are investing your brain, inventing some new technology, then you should get money in return to it. So what you do is, if you have applied for a patent and you are a patent is issued to your name, and then you are asking that what should I do? So this field is known as the evidence of use. So you have to make a study. You have to search on Google. So we search on Google that I have my technology patented, then I will search on Google that what all companies are using this similar type of technology. So this search is known as EOU search, evidence of use search. So we do this search and we get to know that company XYZ is using my technology, and then what I'll do is I will send them a letter. I will intimate them that Mr. X, you are using my technology. I have a patent right for this, and you are not allowed to use this technology without my permission. So there are 2 ways to deal with it. First is you give me money for it and take license from me. This is known as licensing. Or I'll sue you in court. So I'll take money in that through the court, that this amount of, let's say you have 1 crores profit based on my technology, means using my technology, using my, for example, you have this mic, you patented this mic, and that company X has sold your this mic to, let's say, for 100 crores. So he has gained, let us say, 50 crores out of that. Means he sold it for 100 crores and he gained it for 50 crores, gained 50 crores from it. So you can sue that company X to give that 50 crores to me because I have rights, patent rights for this. Complete profit to me. So this is the thing that why you have not asked me before using my technology. So based on this, you can sue other companies. See, the first thing is that you make a mutual agreement. Means, see, in industry, we do not sue directly anyone. We first approach them. We first give them our proposal that, see, you are using my technology, then give me profit. So you have no harm in it. You have invested only in a patent that's less than ₹1 lakh, and you are getting in return 50 crores. And if you have asked that I can settle for 10 crores, means if you give me 10 crores, then we can settle it. I will not sue you. I will give you license. But if you do not give me this 10 crores profit, means out of 50 crores, give me 10 crores. If you do not agree to it, and I'll sue you in court. And then from court, I'll ask for the complete profit you have attained from selling this product. So both the methods are correct, but the first one means first getting a mutual agreement to it, it's better. And it's safe for everyone because in future, he may also sue you. So there must be a balance between both the things, right? Yes.
Like earlier you told about that. So if someone has, and then the patent that somebody didn't know that this technology is used. So if they can't patent, and then later on it's the that that person comes to the patent department. So would it be like monetary then also monetization?
Sorry, I didn't get your question correctly. So you applied for a patent.
No, sir.
Huh.
I didn't apply for the patent. But I was using that technology earlier, like that. So when someone else applied, then I can defensively claim that I'm using.
Yes.
But if they applied and patent has been registered, later on I'm using this procedure. So would I get money at that time also?
No, you will not get, you will not be able to monetize it because monetization can only be done if you have rights for that. If you have rights for protecting that technology. If you don't have rights, see, if you have trademark for it, if you have copyright for it, then you are eligible for suing someone. But if you don't have any protecting rights, then you are not able to sue. Means you can invalidate his patent. You can go to IPO and say, Mr. Examiner, this is the prior art for your this patent issued, and I want to invalidate this patent. This is known as inter-party litigation. It comes post-grant, means after the application has been granted a patent. So it's a post-grant scenario, and it comes under the litigation part. So yes, you cannot monetize it, but yes, you can invalidate that patent also. Right. Yes, please. Okay, so I'm not expert of this trademark because it comes under the field of trademarks. So what idea I have is that if your company is registered, then it comes under R. Logo. See, logo is not registered. Logo, we get trademark for that logo. We get it registered under the trademark office. So if that trademark, we have a trademark for it, then it will be TM. We have a trademark for this, right? And if that company is registered, then it must be R. But I'm not a right person to give you exact answer. I'm so sorry. I am not a field for this trademark. I'm into patents only. Yes.
Can the same thing be patented by two different countries?
Very good question. If you have invented one technology and you are allowed a patent in India and the same person is asking for a patent in US, right? So it depends on the time zone. So if you have first applied for a patent in India, your patent will become prior art or the person who is later applying in US. So if examiner searches for your technology on some database and he finds that this technology is already granted a patent in India, then he will deny his application in US, right? But it all depends on the search which examiner is doing in US. It may not appear to him and it may appear to him. But if we know that my technology, I have practiced technology in India and there is a similar patent in US in others' name, then I can go to US patent office and ask for invalidating that patent claim, right? But it's our responsibility. So if anyone is suing your patent, infringing your patent, then it's the inventor's responsibility to get that right and get that patent invalidated. Okay.
Some patents appear controversial. Means some patent is good. It appears that one party should be given patent, someone thinks that other party should be given patent. In such dispute, like if we have any civil dispute like that, we can approach court, civil court, high court, Supreme Court. Is
Yeah.
there any hierarchy in this system so that if you are not satisfied, you can approach higher court?
Exactly. Earlier it was IPAB, Intellectual Property Appellate Board. So now it is dissolved. Now it is the High Court which is acting as the IPAB. So first we have to approach IPO, Indian Patent Office. If we are not satisfied with the examination and the analysis of IPO, then we should go to High Court. And still, if we are not satisfied with the High Court, then we can go to Supreme Court. But I don't think that's the case. Everything gets settled in the High Court till now. There must be some cases, but generally we don't go to Supreme Court. In the High Court, all these patent cases are settled. So there are many disputes going on right now, but I have not seen anything going into Supreme Court. So that's come under the litigation part. So that's a complete different field, and there are many domains in which we work. So the thing about this suing and infringing, all these things, disputes, this come under the litigation. So yes, the hierarchy is IPO and then High Court and then Supreme Court. There is no international patent as such. Patent is not worldwide. It is jurisdiction based. If we have a patent in India, it's valid in India only. If we patent in US, it's valid in US only. There is nothing like international patent.
IPO or WIPO, how they are correlated?
See, WIPO doesn't grant you patent. WIPO, it is World Intellectual Property Forum, so it doesn't grant you patent. It's a way to file your Indian application to some other country. We go to PCT route. It's known as Patent Cooperation Treaty. So we have some treaties in which almost all the countries are part of it, just like UNO and these all these UNESCO. So under PCT, almost all the countries of the world are part of it, except for I think Taiwan. It's not a part of it. So all the countries are part of this treaty, and if I'm applying for a patent in India, I can go to US via this PCT route and then apply for a patent in US within 30 months frame. I have a time period of 30 months, 2.5 years, to apply for a patent in any other jurisdiction, for example, US. Are you talking in relation to the patents? See, there is no international patent. If I have a patent in India, it's not valid in US until and unless I apply for it. If I have a patent in US, it will be governed by the US jurisdiction and only US rules are applicable for it. If I am having patent in India and some company, let's say Microsoft, comes to India and uses the same technology, then it will, if I sue Microsoft, then all the legal aspects will be covered as per the Indian laws, not the US laws. Although it's a US firm, it's a US company, based company, but all the legal aspects regarding this patent will be covered as per Indian patent laws, not the US patent laws. So there is nothing like international disputes in patent. Very good question, I must say, because there is a general doubt in this that what do we do if we have means multinational companies involved in it.
These questions are arising because we won the case against the Basmati, US Basmati sector company patented. But what happened if we were denied our rights? India and Pakistan could not have been given the Basmati. Then in that case, what would be the hierarchy where we could have approached to get back our trademark or the geographical indication?
See, for GI, so it's not about the, it's not for the patent, it's for the GI, geographical indication. Yes. So, see, that was not a patent, that was a GI, geographical indication. There is no patent for food in India. We have no patent for food in India. We have patent for food in US. We have patent for plant technology in US. But in India, we can't protect these plant technologies. Means method of producing a food, we cannot patent it. So it's for the GI, not for the patent. Right?
Patent is one variety. For them, there are 3 types of patents.
Yes.
Patent is also.
Yes, yes. So the utility application, design applications, and the plant. These are 3 broad categories. Is the umbrella categories.
So for plant, we can get the patent. But plant breed or plant variety, genetic.
No, in US we can get a patent for it.
But India, it's not a business.
No, we cannot get a patent for microorganism in India. So for planting, we cannot get a patent in India. For microorganism, we can get a patent in India. Like for the drugs, we can get a patent in India, but for not for this plant technology. Anything else? Or yes.
That if I search for some sort of patent which are done in the US, simply I search that this type of patent is not done in India. So I just copy and paste, I just made a patent here. I can easily earn.
But it comes under the novelty that your invention is not novel. Right? Because it has already been disclosed somewhere. It's already been in public. So it's not novel. So there are 3 criteria for getting a patent: novelty, inventive step, and the industrial applicability. So it will not come under the classification of the novelty.
Earn if I had a patent, like the previous question that if I have a patent, I can earn. If I'm making that patent even in India, which are already done in the US, which is not
Okay, so you have applied in the US.
someone has applied in the US. I search
And now after some time you are applying in India. Same thing. So that patent in US will become prior art for you, your patent in India. So examiner will say, hey, Mr. X, this is already being used in US. So it's not that if examiner is searching for any prior art for your patent application, he will search only in India. He will search all the literature available around the world. So we have a database called Google Patents. It's a free database. So in this database, we can search for a patent for every jurisdiction in the world. So there are many databases. Google Patent is a freely available. So even we use Google Patents. So it's available free for all. So if you go to Google Patents and search for any technology, it will give you patents around the world. Any other question, please, or right. Wind it up. Yes, please. Exactly. If anything which is new and it is giving you some technical effect and solving some problem, then you can protect it. What do you think that how many patents you have in your mobile phone? How many patents you have in your mobile phone? See, there must be thousands of patents in this phone alone. In this phone alone, the design of that logo on the Apple phone is protected. No one can copy that design. So it's a design patent. The display, the sort of pressure we are applying to it, and it is being means monitored. It is a utility patent. So there are thousands of patents in your pocket, right? In a single device mobile phone. So any addition you are doing to a simple display screen can be patented. Although it is existing, but if you are giving some, let us say, you are reducing the latency of that touch input. So that reduction of latency must be due to some novel aspect which you have introduced in your existing thing. That is eligible for getting a patent. Yes, please.
पेटेंट अप्लाई करने से पहले उसको डिस्क्लोज कर दिया किसी इवेंट में या तो अगर वो गवर्नमेंट इवेंट
12 months. You have 12 months time period after disclosing at any conference, any YouTube blog, anything. You have 12 months time period. Within 12 months, you can apply for a patent. But you have to disclose this to IPO that I have disclosed this in this public domain on this date, and this is within this 12 months time frame. 12 months.
Is it right that government can use our patent in case of emergency, like I have patented something?
Exactly, COVID.
So it is invoking patent right of mine.
Yes, so we have an exception in India, and I must say that it must be everywhere or every jurisdiction. So during COVID, government means infringed patent rights for many companies to manufacture the drugs. So yes, we have a provision, and it's infringing the rights of the patent holder. But this again, one of the main cause of getting a patent is the social service. And if we are not doing it, then there is no way of protecting your invention. So if your technology is not doing any social cause, then only monetization is not the purpose. So this is the reason why during the COVID, many patents was infringed by the government, and it was given to all, and drugs were manufactured because it was a time of helping each other. So it's not about money everywhere, right?
Suppose we have written a research paper, someone else has been patent for it. We use it as an offensive that you told that you can be
Defensive. Yes. Yes. So see, if examiner has searched for it, while before issuing the patent, examiner searches that if that technology is already disclosed or not. So if he searches and finds out your conference paper, then examiner will give it to that applicant, inventor, that see, this invention is already disclosed. It is already available to the public. And if by chance he misses that conference paper, then you have an opportunity to go to IPO and get that patent invalidated. But you have to track all the patents which is getting issued on a daily basis. So if we have a tracker on this IP India website where we can track all the patents which is getting issued. So we can track it. But this is a tedious task. It's not an easy, because hundreds of patents are issued daily, and you cannot see each and every patent and what technology is being disclosed. So this is tough, but yes, it's our responsibility to check whether anyone is infringing our rights or not. It's not the IPO responsibility. It was very nice interacting with you, and great audience, great environment. It was nice interacting, having this patent workshop. Thank you so much.
Thank you very much, sir, for sharing your valuable insights and expertise with us today. Your talk on IPR was both informative and educating, and I'm sure it would leave a lasting impression on everyone here. Now, I would like to call upon Dr. R.K. Srivastava, HOD Civil Engineering, for presenting a gift to Mr. Gaurav Gupta as a token of thanks. Thank you, sir. Following the thought-provoking talk by Mr. Gaurav Gupta, we have now pleasure of hearing from Mr. Himanshu Sharma, Project Manager, Tenges Research Private Limited, Gurgaon.
I request Dr. Avdesh Gupta, Professor in charge, to kindly welcome Mr. Himanshu Sharma with a sapling.
With vast experience in intellectual property, his expertise lies in the drafting of patent application for the US, EP, and IN jurisdiction. He also have hand-on experience in patent analysis. I would request Mr. Himanshu Sharma to please come upon the stage and enlighten us.
So good afternoon, everyone, and I just convey my thanks to all of you that you have given me this opportunity that I'm presenting all my insightful regarding the intellectual property to you. So definitely a lot has been already spoken about the patents by Gaurav. So already you have, I mean, most of your doubts definitely has been resolved till now. But still, I just want to throw some lights on the other aspects. Since a lot of talk has been, already done regarding the patents only. So I just want to talk other topics other than the patents. Since the intellectual property doesn't only contain the patent, there are many other aspects also. There are many other protections also we sought, like trademark, like copyrights, like design. So these kind of, different aspect of the intellectual property. I just want to discuss all of these. So by you can say that by saying intellectual property, you doesn't mean that it is a kind of a property, because sometimes it happens whenever you will say that I'm a intellectual property professional, most of the people's get confused about that with that property word. So definitely it's a property, but it's a intangible property, you will say, because you can't touch it. It's not tangible. So intellectual property is just creation of human mind, you can say. So there are many there are many methods you can protect your creation or your thoughts, like patents, trademarks, and copyrights. So if you want to, okay, so let's I'm just giving you an example. Yesterday, since I was living in Noida, so definitely I came to Gaurav's house for today's session. So yesterday evening we were walking on the road, and a car just passed away beside us, and it is having a logo of 4 rings on the back panel of it. So we were just arguing that whether it is a Maruti Suzuki or it's a Hyundai or it's a Honda. So definitely you can answer it, because that the famous you can say mark you must be aware of. Okay, so this is the, you can say that this, I'm not saying that I don't know what the mark is, just directing the conversation towards it, because that way you will be able to learn more. So here comes the you can say the trade is what? Trade in the mark. You are able to recognize all these things just by looking at the symbol. So trademark is a 3D object or 3D shape, any kind of, it can take any shape. It can be it can just represent you. It just represent you that how you are doing your business, and just it has some value with it. Like you said that it's a Audi you can say Audi vehicle. So Audi has a different kind of mark, which is you can say propagated to the world, that this kind of thing is belong to this manufacturer. No one can use that mark. So like Audi, every other you can say vehicle manufacturer have their own marks. like S for the Maruti Suzuki, the H for the Hyundai, and the H for the Honda. You can see there is some difference between the Hyundai and Honda. These are not same. Hyundai is kind of, I mean, you can say italic word and written in a circle, and Honda is kind of, you can say, has a different design for it. So you can identify the products by looking at the marks. And no one can use these marks, and these marks are used to, I mean, they just give you the recognition that, yeah, you are building these kind of products and you are doing that kind of business. So this is good for your business. So this comes under the trademark. You can say trademark act or trademark. Anything can be trademark. If you want to, you can say represent your business. If you want to represent your business in any way, then you just have to identify a symbol, and you just need to relate it with your business or anything, and then you can have a trademark for it. And then next one is copyright. You must be aware of that word, because most of the time whenever I say that I'm a patent professional, no one can understand. But whenever I relate it with copyrights and all these kind of thing, then the people get an idea of it, because copyright is famous for that, you can say lyrical musical composer. So that's why everyone is aware about that copyright thing. So have you ever know what thing can be copyrighted and not? So definitely you must have some idea, because due to that, song and any literary art, any literary lyrical and all these kind of things can be copyrighted. Then there comes a industrial design thing. So everything has a design with it. Have you ever noticed that the Pepsi bottle and Coca-Cola bottle, they have a separate, you can say, design for it? Anyone can't replicate it in their products. They have to take a permission, and it is, I mean, it can't be given to anyone. Coca-Cola will not give their permission to use their shape of bottle to other competitor. So that kind of thing can be covered under the industrial design thing. You can have a protection for your design, like Coca-Cola has for their bottle, like Pepsi has for their bottle. And you can say whether it comes under the trademark act, because Cadbury, you must have heard that purple color is related to that. So this is also kind of thing that is trademark. So so there are four kind of properties I have discussed, like trademark, patents, and copyrights, and industrial design. So if you want to know anything in detail, then you can ask some questions regarding it, and I will be happy to answer all these if you have any doubts regarding that. And that I think someone has asked about that R and TM. So yeah, actually whenever you file for a trademark or a patent, then since Gaurav tell you everything that it has a process involved with it. So definitely it takes a long time in order to have a grant for a patent or for a trademark. So during that transition, you need to tell people that I'm using it, or I have applied for a patent for it, or I have applied for a trademark for it. So that there comes the difference. The TM sign, what you are saying, is used by many people in order to show that yes, I have filed for a application. I have filed for a application for this trademark, and that R is known as the registered trademark. When it gets registered, when they have the protection for that trademark, then they use it. Use it to show others that yes, I have now. I had applied, and now I have the trademark for it. Now I have a grant for it. So there comes the difference between that R and TM. Similarly for the patents, actually whenever you apply for a patent, right away you can't get the protection for it. There are certain steps, like Gaurav told that there comes the publication, there comes the examination, and then there comes some opposition. If it ever happens in between, then there is also a thing, opposition. If I want to go in little deep, so whenever I apply for a patent, then after 18 months of time period, if I apply, actually patent, whenever you apply for a patent application is get published within 18 months or after 18 months. if you want an early publication for it, then you can also apply for it. Then in that case also it will be definitely will take within 18 months, because some time has to be passed before publication of that patent application. By publication, what you are doing, or what the patent office is doing, they are just letting others know that yeah, this kind of invention, this kind of production is already been sought under this application. So please, if you are focusing your research in that direction, so please refrain, because this kind of application is already been filed and it has been in prior art. So that there comes the benefit of the publication. But since the application is only published and it is not been granted yet, but you can seek protection right away after the publication, because publication, what you will say, the publication is only thing that yeah, you are just letting the others know that I'm using this invention and I have already filed to have a patent for this invention, and if you are using anyway, then I will be going to sue you in the court or in anything. So definitely these kind of thing, yeah, happens after the publication. After publication, you have to apply for the examination of the reports, at examination of your patent application. See, if you want to know, actually, I just want to discuss the life cycle of the patent. Whenever any idea you have, or there comes an idea in your mind, then how will you proceed till the grant of the patent? Okay, so since we are the patent attorneys, so we are handling the different clients. So we were in talk. We definitely every day we have a talk with the inventors regarding their invention. They just come to us and said that yeah, this is my invention and I just want to have a patent for it. So we discussed that this is novel or it is already in the prior art. If it is already in the prior art, you can't have a patent for it. Then the inventor definitely reply the same way that yeah, it's novel, because everyone has their emotion with their invention. So they just can't accept that anybody else is already using it. They just can't accept it, and they just said that yeah, this is novel, and we are planning to have a patent for it. After that, we suggest them to go for patent searching, because everyone doesn't know anything in this world. So there is a separate service for it. So we charge a kind of buck for it, and then we perform the patent search on the databases related to the patents, like Google patents. Gaurav had discussed. There are several others databases also which are paid. Since you search anything on the Google, it gives you junk results. Sometimes it doesn't give you the relevant results. You need to find the relevant result in the junk. So that's because the Google, what is Google patent? What is Google patent, or what is Google, you can say, search box? This is a free to everyone. And you are thinking that why anyone will provide their service free? Why? Because Google, the results on the Google can be, you can say, can be manipulated. We pay to Google some kind of, money, and they will show our result on top. So these kind of thing happens with the Google patents and the Google search database. So that's why there comes the paid database. They just charge money for their service, and we use those databases like PatSheet, PatSnap, Orbit, Coastal Orbit. There are many other databases also. So we use these kind of database just to get, be sure that what we are searching, it is reflecting in the results, and the junk is not coming in our results. So that's way that way we proceed towards patent searching. And we, like Gaurav said, we just don't search in the India, we search it worldwide, because everything is, if it is patented anywhere in the world, you can't get a patent in India or anywhere. Yeah, you can use it. Actually, there comes a, you can say, logic. If I applied for a patent, if I already applied for a patent and I have a patent in US, but I don't have the same patent in India, then anyone in India can use that invention for their purpose. They can use it or they can sell it even. no one will be able to question it. That if because the firm doesn't have a patent in India. It, if he wants the protection in India, he need to treat it like a designated country in their PCT application. So these kind of things happens in this procedure. So patent, you must have heard about that. It is a territorial right. So if you have filed in US, then you can't use it in India that I have already applied in US and I have rights in US, so definitely I have also the same right in the India. This is not true. In India, you have to separately apply for it. So after patent searching, there comes the drafting of the patent application, which is disclosing all of your functional and technical aspect of the invention. Drafting, you can say that it is a different thing. Like some students have asked that they can draft their patent application and all these kind of things. Yeah, they can do it. They don't need a patent agent for it. But see, if anyone can draft a patent application, then there is not a, we were not, you can say that we don't have any valuable significance in that. There is a separate industry working for that purpose only. Like we used to draft a patent application. So if anyone can draft, then why will people ask for our service? That yeah, please draft our application. So you can't just write anything in your patent application because it kind of a techno-legal document. You are just explaining your technology in legal words. So definitely you can't have that sense. If you are new to this field, you just want an experienced person to handle all these kind of stuff. So due to that, we are existing in this world, that we, as a patent attorney, you will say. So we draft the patent application, and after the drafting of the patent application, we file it to the respective patent office like USPTO or IPO or like EPO, European Patent Office. And after filing of the patent, there comes the examination. There comes the examination of the filed patent application. Then the examiner will give us the report, examination report. The patent searching, which we have already performed before drafting of the patent application, the same search is performed by the examiner or by the controller in order to see that whether this application is novel or this should be granted or not. So the same process has been followed again. And if he comes at the conclusion that yeah, the application is novel and it can be granted, then he give his note about that. If he is not sure about the invention, you can say that come around some invention, come around some patent which are already, you can say, related to our invention, which are kind of similar to our patent application. Then he cited those patent number or those application in his examination report, and the examination report come to us that yeah, please differentiate between your invention and this invention. How it is different from this. If you are able to distinguish, then you can have a patent. If you are not, then please you have to withdraw your application or it will stand cancelled. So after the receiving of the examination report, we prepare a response for it, which contain all the other, you can say, the distinguishing features of each and every invention, that how our invention is different from the others. And if the examination, you can say, satisfied by our response, then he grant the patent right away. Otherwise, there comes the second examination report that yeah, I can understand what you are saying, but still I am not satisfied, and I also come across these documents also, which can be included in the which can be used in combination with the first examination report. So please also, we need to again draft the same response, disclosing, distinguishing our invention from the other invention, and the same process follows. You can say to and fro happens, and if we are able to finally satisfy the examination, then we can have a patent. Otherwise, the patent application stand cancelled. So yeah. Yes. If you are, see, the mascot and logo, both are different thing. Trademark is for the logo. for logo or for symbol or for all these kind of thing. However, the mascot, if it is anyway related to your business, you can use it, but I don't think that's the part of the trademark. What I will say, suggest, yeah, you can use it, but that's not the part of the trademark. You can separately, you can have a trademark for only one, you can say one feature like logo. Then you, if you want to separate protection for the mascot, then you have to separately apply for that. That, yeah, this is my another, you can say trademark. Sorry, I. Yes, yes. If it is already registered, no one can use it. I mean, it is way to, like, same way we file the patent application, there comes the trademark application where we need to disclose our logo. Like in the patent application, we need to disclose all technical and all functional aspect. We need to disclose that, disclose in that in our trademark application that this is the logo. Like you can say that S mark of Maruti Suzuki, it is completely, you can say, written in that this exact logo represents my business and it should belong to me only. So that way you have to, I mean, file in the trademark application. You can't do any other way. You need to. Yes, yes, yes. Yes, yes, yes. You need to, I mean, you need to mention it in your application that, yeah, I am applying for this mark. And you have to, I mean, draw it, or you have to, I mean, you can use the computers, but you have to draw it in your application. Then only you can get. Otherwise, you can't. No, no, trademark is not registered for. Mhm. Yeah, renovation definitely. Actually, the renewal of the yeah, yeah. Trademark is for lifetime. I mean, no one can use that OD4 rings for, I mean, only 10 years. This way, trademark doesn't work. Trademark is for lifetime. If you have applied for a trademark, then you can use that for your lifetime. So that renewal part you must be talking about, because every with every invention, or with every, you can say, filed granted patent application or granted trademark, you need to renew it. So you that way the government receive the payment from inventors or all these kind of thing. In the patents, you need to, you can say, you can need to pay renewal fee after every 2 years. So that way can happen that in the trademark it is like after 10 years. So it can happen, but I'm not aware about that part, that if it is after 10 year or what. Okay, then you need to renew it. Then you need to renew it. It is like that only, because trademark is for lifetime. You just can't have any trademark for 10 years or 5 years. And patent is also is only for 20 years, because we want to promote invention. We want to promote innovation in our, you can say, social network, or in our country, what you will say. Because if we are like the government just want two things from us, that please, you can have the right, but you need to write it in a detailed manner in your patent application. You need to write it. What is the benefit of writing all these details in the patent application? Because government wants others to know how this invention is working. And that way, if someone is already, I mean, skilled in that particular field, he can draw their insight from that patent application that can be beneficial for further invention. If and he understands that invention, yeah, that, yeah, he has invented something in this way. So there might be a chance that if I proceed this way, I can also invent something. So that way, I mean, government is promoting innovation regarding their invention in the people's mind. So this is the, I mean, you can say both comes in a side by side manner. So anything, anyone other has any questions? Mm-hmm. Yes.
Can it be provided to some other company
Yes.
who want to use it?
Look, this process is same for patents and trademarks and everything. Actually, sometimes what happens, no, you have a patent for your invention or you have a trademark for your trademark. You have a trademark for your mark. So that way, but after your after your grant, look, you can say that the you applicant has died or the you can say the company gone bankrupt. In that case, if any other person is interested in that mark, he can separately apply for it. Or if what you are saying that the bankruptcy only.
Well, then that if the company is very renowned, some simple person can,
Mhm.
it's very well done, it's not.
Yeah.
But suppose I as an entrepreneur, I want a trademark, very common, first of it I'm making.
Mhm.
So, isn't it cheating for those who are imagining that, who are imagining that,
Actually, these kind of thing can't happen because if that company is so big, then definitely if I mean if the condition is like that it is at the at the verge of bankruptcy, then definitely other competitor will definitely buy it. So all the rights related to that will automatically get transferred to the new firm. Okay. No, but he can use it if it is at trademark. I mean, if he has the right for it, then he can use it. If he don't want to use it, yeah, still that right belongs to him only. I mean, no one other can use it because he has already followed that process of I mean applying for it and getting a grant for it. So any no one other can use it. Yeah, you don't want to use it, so you just I mean yeah, but since he was using it and he can use it, but he doesn't want to use it now. So yes, yeah, he's using other symbols now.
why is not updating the trademark for Twitter? Put it is now open in public domain. I take this trademark and I,
Mhm.
so am I allowed to use that trademark?
Sorry, I can't. I mean, understand you.
Just not using that X, no X, what is this, then the trademark is X.
Yes, yes. Hmm.
Now, if Elon Musk doesn't update it, doesn't get the renewal of that mark, and I purchase that mark, and there, can I purchase that mark not being renewed by him and it is
But it is already in prior. See, it is already in prior. You can say no.
license, but is not updating the same and it is not allowing others to use that.
I mean, you can't duplicate your mark related to, I mean, any other already registered mark. Even though it has been lapsed that you can't use it, but since it is in prior, this will create confusion in people's mind. This will, I mean, this will same go for the patent also. Yeah. So you can't use it because it is already in the prior. So it does belong to some other entity, and yeah, it will definitely create a confusion. So you can't do that way. Yeah, that comes under the licensing thing. Yeah, that comes under the licensing thing. You can do that. You can do that. What I told you, if you are using that symbol for your operation or for your business, then it will create confusion in people's mind that definitely it's a big bazaar only. So these kind of practice are not promoted. I mean, not encouraged by government. You can't use that. You can have your separate you can say logo which can represent your business or your operation, but you can't use already registered trademark because it is already in prior. It does have some value with it that yeah, it does belong to big bazaar thing. So it will create confusion in people's mind. So definitely it's not encouraged. No, copyright and trademark. I mean, these are the lifetime values for you. If you have any mark, then I mean, you have any registered trademark, then you can use it for lifetime. Same goes for the copyright also. Yeah, actually, I'm not aware about that copyright thing. If you are going that way, but these are for the I mean, these are for the lifetime use. The as far as I know, so yeah, yeah. I mean, basic intellectual property is a very wide, you can say, field. So there are many things we trademark handled by mostly the legal person, the LLB person, and all these kind of things. There comes the actually the intellectual property since it is a legal field. It has been operated by the legal peoples only. You can say before 10 or 5 years ago, but then there comes a certain kind of, you can say, scientific thing that the lawyer can't understand. So they hired engineers in order to understand that technology so that they can have a draft for that patent application, and that way engineers acquire this field, you can say. So engineers can, you know that they can work everywhere, and whenever they are into something, they just acquire it. So these kind of thing happened in this industry also. We just, they gave us entry in this field, and then now we are ruling this field, actually, you can say, because we can understand the invention better than a LLB person. He doesn't know anything about it. But yeah, if it is trademark and all any other thing, then he know way more than us, because it doesn't have any scientific knowledge involved in that thing. This is just a mark, and the application is also very simple. You just need to draw your mark and you need to file it. Yes. This is application is very simple, and you can say copyright is also a very simple thing, because you just need to draw your code, or you need to just draw your lyrics and all these kind of thing, or you can say tone, you can say what we'll say, how they actually, there is a certain way you express your music. Yeah, harmonical form. Yeah, definitely. So you can draw there on a paper and you can directly file it. But these kind of things are not simple when it comes with the patent. Yeah, so that's why engineers are involved in that patent thing only. They doesn't, they know about it, because since it is part of intellectual property only, but they are not, very deep dive into that trademark and copyright thing, because it is very simple thing. So patent is a whole way complicated process. So in order to get a patent, or in order to file for it, you need a certain knowledge. So that's why these kind of thing happens. So any other doubts if you want? Okay. Okay, so you are assuming it. You need to be assured about it. So if you come to us that, yeah, I have invented an invention. Actually, we have a separate, you can go to any intellectual property firm, or you can go to any patent attorney, or any Indian patent agent, registered patent agent. Actually, this depends on the skills of the person doing that search. If you can also perform the search. What I am saying, anyone can draft patent application, anyone can search for the prior art, if any invention is already in the prior art or not. But how beautifully you are able to do it, that depends on your skills. You can't do it you can't do it in the same manner I am doing it, because I do have experience with me. So yeah, I can perform very beautifully, or you can say I can found a bang on result. Yeah, definitely. Google patents. This is no, Google patent is free for everyone. Everyone can access it. Yes. We still use Google patents only. Okay. Yeah, you can go to Google patent. Since you can say that you have invented a new kind of glass. So you know that there's some, you can say that shape, or what you will say. Yeah, you have used a new material for making a glass that you can eat it after drinking the water. So it is, using for containing the water, and you can also eat it in order to, remove, in order to, have a, what you will call that, in order to satisfy your hunger, or what you will say. So you have invented a new material for building a glass. So that way you can type on the Google patent or Google database that the glass which can be eaten, or there are certain tricks involved with that. So how beautifully you are going to do it, that depends completely on your skills, but you can access that Google patent database. Actually there are certain ways to. Yes, Google patent is free, like Google search. It is free for everyone. All the
inspectors, those who are going to give the are also accessing the same data.
Yes. We are. I only said that we also using Google patents, but since there comes a, I mean, whenever it comes free, there comes a cost with it, definitely. So anyone can go and search on the Google patent, but it gives junk results also. I mean, sometimes you will see that the results are not related. You are searching for a glass which can eat and which can be eaten, and the results is showing something different thing. So that way you need to, I mean, you need to put your efforts in that how will you able to get that relevant result. But you can use it for free, and it is already, if a patent is already granted, then it has to be in the Google patents. If any other doubts, if you have. Yes. Can you please repeat it actually? मैं सुन नहीं पाया. Okay. Actually, you can't get a patent for a garment. I mean, you can protect it under industrial design thing. I told you. Like the Pepsi is protecting their bottle and the Coca-Cola is protecting their bottle. Because they have a separate design for it. So if you have any other separate design for your cloth or for your blazer, you can sort a protection for it under the Design Act. You can't have a patent for that thing. It's okay. I mean, your question is little bit confusing, but I mean, what I understand, I can reply on that. You are saying that a company is using, I mean, some product, and just you want to put some extra feature on it, like you are just want to, I mean, draw a symbol to it, but you can't use, I mean, you can't use someone other's protected invention or protected trademarks to, I mean, utilize yours. You need to file a separate thing, and you need to, I mean, acquire a separate cloth or what you are saying. You just can't use someone other's cloth, I mean, blazer or that kind of thing. You need to purchase a cloth. You need to, I mean, separately made it, and then you can put your design or logo and symbol on that. This way, I don't know what you are saying, because there is coming to some confusion in your question. So, but it's still, if you have anything.
Company can imitate the brand. There is a brand like Kotak Bank.
Okay.
Bank, Indian Kotak Bank. Sometimes they are hard to do the business. Sometimes they are not. Like quality ice cream is also there. Quality ice cream is also there. One is starting from K, other is from Q. So, what is the criteria on basis of which company is allowed to do the business?
Actually, that, I mean, that is totally on the controller, because whenever you file for a mark or for a patent application, then it has to be examined by the controller or examiner. Then what comes in his mind, he can issue his decision regarding that. If he is thinking that, yeah, it is, I mean, creating confusion and the similar mark is already existing in the prior art, he will not give you. Then you can, I mean, on the hearing, you can argue that, yeah, my mark is different from that mark. You can say that, but if it is totally on the controller, that what will he think? If he gets satisfied that, yeah, you are saying what you are saying is correct, there is some kind of distinguishing feature in all in between both marks, then he can, I mean, he can give you a grant for your mark. If you are not able to satisfy the controller, then you can't have.
Sometimes one open case of Yahoo is there.
Yes.
Yahoo India operating in India by Apollo was closed. The operation was stopped from Yahoo Internet.
Yes.
Because Yahoo part is there and on basis of
These kind of thing can happen. I mean, because they are just, I mean, if you like, you can say the Burger Singh and the Burger King. both these kind of thing, but they have a separate, I mean, they are the landmark judgment on that on those cases. So yeah, they have their mark, Burger Singh, but since it created a budge between the people that how it can, because it's kind like Burger King only, but they are able to, I mean, satisfy the controller that our mark is different, and that way they had a protection for it. Otherwise, these kind of similar thing, I mean, people use these tactics in order to establish their brand by relating the other famous brand, which is already existing in the prior art. Any other questions? Okay. So definitely we have consumed a lot of time of yours, and hopefully we will be able to add some you can say knowledge or these kind of thing in your mind. So thank you so much for inviting us and organizing this session.
Thank you, sir. I would like to call Dr. Rajesh Prasad, Professor in charge, for presenting a gift to Mr. Himanshu Sharma as a token of gift.
Before we go deeper into the next segment, I would like to call our 1 hour lunch break and request all the guests to proceed to the lunch area. The session will start from 2 p.m. onwards.
Welcome back, everyone.
With great anticipation, let's turn our attention to our next speaker, Dr. Ruchika Gupta. I request Dr. Sonam Gupta to kindly welcome Dr. Ruchika Gupta with a sapling.
Dr. Ruchika Gupta, with an impressive academic experience of over 2 decades, she has excelled in various roles as a teacher, trainer, mentor, and administrator. She is the former dean of ABES Business School, director of Noida International University, head of Amity Business School, and head of PhD programs, research, consultancy, and international affairs at Amity University, Uttar Pradesh. Holding a doctorate from the University of Lucknow, she has also attained 3 master's degree in MBA, MCom, and MSc. Her areas of expertise lie in finance and IT, where she has conducted extensive research focusing on interdisciplinary studies in technology and management. She has organized numerous conferences, seminars, workshops, and faculty development programs, and also chaired sessions at several international conferences. She has taken several training sessions for the corporates, including Zydus Wellness, Varun Beverages, PepsiCo, to name a few. She has presented and published more than 100 research papers in renowned national and international conferences and journals. Her work has received wide recognition, resulting in the grant of 37 copyrights and 6 patents. Moreover, she has authored 7 case studies and 2 books with renowned publishers. She actively serves as an editor, reviewer, and advisory board member for several indexed journals. Her remarkable achievements have garnered numerous accolades, including the Women Empowerment Award and the distinguished title of Best Professor in Information Technology. She is also a certified trainer and judge for the Social Innovation Generation Program by HEC Montreal. I request Dr. Ruchika Gupta to grace the stage with her presence.
Thank you so much for such an impressive introduction. Yes, very good afternoon to all of you. It is an honor for me to address such a learned professors gathering. First of all, let me thank Dr. Sonam Gupta for inviting me and the management and the organizers for this FDP. I believe these kind of FDPs are the platforms through which we share our knowledge. Whatever little knowledge we develop over the period of time, these are the platforms where we can share. And I believe with the, as I mentioned, I believe with audience like you, it's not only the knowledge sharing by me. I believe at the end of the session, I'll also be having a lot of knowledge out of you people. So as I came to know that there have already been 2 sessions in the morning based on the introduction to IPR, right? And to me, being an academician, the theme that is given is the introduction to IPR from an academician's perspective. So before starting with my presentation, I would like to know that what are the few things regarding IPR after attending first 2 sessions would you like me to focus on? Because I believe after lunch, it is very difficult to stay alert. और आई थिंक एज एकेडमिशियंस हमारे लिए 2 घंटे या 1 घंटे बोलना आसान है, बैठ के सुनना ज्यादा मुश्किल है. Yes. So, what are the challenges? I believe आप में से सारे लोगों ने patents या copyrights खुद कराए भी होंगे. right? How many of such people are there? I'll just have an idea that what are the things, I mean, from where to start. कितने लोगों ने already patents कराए हैं? Patents, copyrights, trademarks, any sort of IPR. Okay, a few. Okay. Okay. So, would you like me to begin with what are the different forms of IPR? Or shall I proceed further for the focusing on the patents and the copyrights? Why I'm saying only the patents and the copyrights? Because as academicians, our main target is more towards copyrights and patents. क्योंकि जितनी सारी चीजें हम डेवलप कर रहे होते हैं वो ज्यादातर उसी पर्व्यू में आती हैं. Right. Okay, let's do one thing when I'm not getting feedback from the audience. Let me start with whatever things I feel that it's been already covered in the previous sessions, I'll skip them. I hope that helps. How to manage with the presentation? Can I have the remote? You can give it to me, I'll manage. It's already audible. Yeah. Intellectual property rights. Whatever we know about IPR, it's already there. So de dijiye. It's better if I yes. Acha, theek hai. I hope I'm audible. I believe picture worth 1,000 words. Right? ताकि कम बोलना पड़े post lunch session. I think the picture trying to demonstrate that we are trying to keep these valuable pieces from theft. The same way is our intellect, whatever we have in our brains, how to protect it. Because there are plenty of questions. This is an idea can change our life. But how can we differentiate that whether the idea that is striking to my mind is an original thing or the same idea multiple people might be having? Or is it really an idea or not? I think all our creativity and innovation, this is the first stage at which we got stuck. For any copyright, for any patent, for any sort of intellectual property, it all starts with some sort of innovation, some sort of idea. So at one point of time, we are struggling with that, how can I understand that whatever is striking to my mind is an idea, right? Then the second phase starts, that if it is an idea, how can I protect it? Shall I first tell it to the people or shall I first protect it? So I believe these are some of the questions which might be striking to you as well. So it's just like a bicycle lock is used to protect the bicycle against theft. Similarly, the intellectual property rights protects our intellectual creations. Same thing. Sometimes we believe that word would be a better place if we freely share our ideas and thoughts with others. The others will also share their ideas and thoughts.
What a beautiful word it would be, but it actually doesn't happen. We might be sharing our ideas with good intentions with the people, but everybody is not that good. Everybody's intentions are not that pure. So there comes the problem. There comes a need for protection. Otherwise, it would be much better that if I had one idea and all the people in this auditorium have one idea each, we would be having plenty of ideas. Now, another problem is, in case of innovation, another problem is the market failure. Now, let us understand market failure in terms of the money which we are going to spend to get it developed, to get it patented or copyrighted. Everything incurs money. Now, is it worth spending money on that idea or not? Who is going to tell us? I mean, well in advance, whenever an idea is striking to our mind, at that point of time, it is us who need to decide that how to proceed further with this idea, whether this idea is patentable or not, or it is merely just a daydreaming. Because unless and until we develop a prototype for that, we are not able to understand whether it is feasible or not. Feasibility in terms of all aspects. Whether they're technically feasible, operational feasible, or financial feasible, marketable, legality, all those aspects are there. So that's another challenge which we face, the market failure. Now, this market failure becomes more complex because then we have private incentives and social incentives. We are social people living in a society, but we have our own individual interest also. Each one of us, obviously, being a social person, we want to contribute towards the society. We want to develop those things which can help people. Right? May it be research in the medical field. That is a social service, we can say. Though the medical expenses are too high these days, so we can't purely say it's a social service, but whatever inventions have taken place, they are doing good for the mankind. So at one point of time, we have social incentives. Then what about our own personal incentives? If we are getting funding by the government or any sort of sponsorship, the social incentives can be easily met out. But in case of shortage of funds, or in case we have to pay out of our own pocket, then our incentives also play an important role. That's what it's been depicted. A fire in a train. Our societal norm says we need to help each other. But actually, at that time, at those critical situations, the personal incentives comes on priority. So it depends situation to situation. If we feel that we can serve the society, then it's okay. Why we are discussing this? Because this is making the market failure portion more complex. When we are paying out of our own pocket, that risk is becoming higher. What if after spending so much of money, after spending so much of time, we are not able to convert it into something which is marketable? What would be the use? So whatever we have discussed so far, based on that, innovation is costly, innovation is risky because of the market failure, and innovation is prone to imitation. Now this imitation. There has been a wonderful article in Times of India a few months back, which says imitation is the new innovation. And that was said in context of India and other developing nations like India. And why they say imitation is the new innovation? Because if you see what kind of innovations are taking place, we are not talking about inventions. Please mark my words, we are talking about innovations. Now, in terms of innovation, if we look at the recent innovations which has taken place in the past few years, some of them, I'm not saying most of them, some of them has merely been imitation. Imitation in the sense, what is happening in the European countries, the same sort of things are being imitated with slight modifications to suit the needs of the customers in our country, and they become successful. Plenty of examples. Whether it's the food delivery apps or Zomato or you name any, those kind of things already were there in the Western countries. With slight modifications. So that's why they mentioned that imitation is the new innovation. One can think on those lines also. It's not necessary that altogether we need to have a completely different idea which no one has thought of. We are not talking about inventions. We are talking about innovations. Just analyze a few examples of innovation. You will find that what I'm saying makes sense. May it be the use of sensors, for example. The sensors were not originally designed that someday they will be used at the airports or nowadays in almost all the buildings for the gates opening and closing. The multiple uses of RFID technology. The technology has already been there. It's all about its new uses, its new applications, which can solve a problem that we call need-based innovations. And this is the situation with which I started my session. That because of these hurdles, we think it's better not to focus on innovation. जब तक चल रहा है चला लेते हैं. But all thanks to the accreditation bodies, they are pressurizing that if you want good ranking, you need to focus on research and innovation. Now, who is going to do research? We, the people. There comes the pressure. Even if there is a pressure that we need to innovate, because academics is always associated with research. Right? We need to be updated. Whatever we are teaching, though it is an old age subject, but every time we are taking up a subject, we need to know what is happening. What are the new things which has taken place in that subject? And we are the ones who are coming up with those innovations. The only thing is we need to strike a balance that whatever we are thinking, let's find out ways that that idea can see the day, can see the light of the day, can be convertible. Marketable is another step. There are number of patents which are not marketable, but still on paper, they are numbers. Who has filed how many patents, who has filed how many copyrights, how many of them are granted. Right? The first stage percentage is too high. The patents published. I believe after these two sessions, whatever terms I'm using, you all are getting it clear, right? So the first stage patent published. So there are, if you see the statistics, the patent published percentage is too high. Then if we see the next stage, after years, the published patents are not being granted. And that too, if you see the comparison, the design patents percentage is again too high in comparison to the utility patents. Because that is comparatively easier. And then even if the patents are granted, how many of them, I have included statistics in some of the slides, how many of them are actually marketable? Believe me, once we know the art of patenting or art of copywriting, we can increase the numbers. We know how to differentiate our idea from the rest of the. It's all about the claims we are putting on. We need to just play with the words. It's not that difficult. But marketability, of course, is a major challenge. So let's proceed further. This is just for reference, because I believe that that's already been covered. Here, there is sometimes there is a confusion regarding the designs. Somewhere in some of the countries, they call it industrial designs. Somewhere they call it design patents. It is a category of patents. GIs are the geographical indicators. So copyright, I think I can skip this. Industrial designs, trademarks, geographical indications, patents. So I think let's focus on patents. And then maybe the time permits, I'll show you a live how we can file the patents and the copyrights. Now there are several aspects, like patents have territorial jurisdiction. हम कहाँ फाइल करें पेटेंट, किस कंट्री में फाइल करें, खुद फाइल करें या किसी अटॉर्नी के थ्रू फाइल करें, who can prepare the draft on behalf of us, right? Which is more feasible. और किसी दूसरे कंट्री में जाके हम कर सकते हैं या नहीं कर सकते. And if we want a complete protection on our intellectual property, कितने countries में अलग-अलग फाइल करना पड़ेगा? Right? Or shall I file a provisional application? I mean, there can be plenty of questions related to that. Like, for example, I have an idea. Now, what should I wait? Shall I convert it into a prototype and then go for filing of patent? Or shall I apply for a provisional patent and then I'll be getting a 12 months time period in which I can develop a prototype? So So shall I focus on all these questions, or these been covered in the previous sessions? Almost covered. Okay. So let's proceed further. Just look at the scenario. It's like looking into somebody else's premises. What is happening? Now, this can be very dangerous in case of pharmaceutical business. Medicines, what are the ingredients? The composition, we call it. Just consider difficult to originate but easy to copy. These needs to be patented first. Originate करने में सालों लगे, experiment करने में, but copy करना आसान है. But again, another problem comes if I decide, let me go for a patent, right? I need to share my idea, and the government will share some of the information when they publish that patent application. That would come in the public domain. पेटेंट जब पब्लिश होगा तो वो इंफॉर्मेशन भी तो आएगी. So again, we are at the crossroads that what is more suitable. पेटेंट करा के प्रोटेक्ट करना है, उस प्रोसेस में वो पब्लिक डोमेन पे इंफॉर्मेशन डालनी है या किसी को पता ही नहीं लगने देना विदाउट पेटेंटिंग. लेट्स ट्राई टू कीप इट अ सीक्रेट. That's what I was talking about, information sharing component. और आप में से जिन लोगों ने पेटेंट्स कराए होंगे, पेटेंट पब्लिश में आपने देखा भी होगा, या जब हम सर्च करते हैं, whenever an idea strikes, the first thing we do is search कि ऑलरेडी इससे रिलेटेड कोई पेटेंट अवेलेबल है या नहीं है, और अगर अवेलेबल है तो उसमें क्या क्या क्लेम्स हैं, हाउ कैन आई डिफरेंशिएट माय आइडिया विद दोज. दैट पेटेंट सर्च इज द फर्स्ट थिंग, द प्रिलिमिनरी थिंग वी डू. सो वो सर्च भी तो उसी डेटाबेस से हो रही है विच इज देयर ऑन द पब्लिक डोमेन, और उसमें से सारे ग्रांटेड नहीं है, पब्लिश्ड भी उस डेटाबेस में है. So that information sharing component, we need to focus on what is more suitable to us. I think we can skip with this. This is already we discussed. One single bottle of Coca-Cola is a very good example that within a single product, there can be multiple intellectual property rights which can be claimed. I mean, a single bottle which is having the Coca-Cola written on it, that must have been protected by a trademark. The shape of the bottle is an example of industrial design so that no one else can copy it, because the shape also makes a lot of difference. The patent may have been obtained that how they are bottling it, their bottling equipment, might be they have got it patented. The copyright in respect of the text, the database, or the artistic work, whatever they are doing, they might have obtained copyright for that, or on the content which they are providing on the website. All those things are protected under copyright. So a single product and multiple IPRs.
One thing is trade secret.
Yes, sir. Trade secret is also there. The composition. Now, this is the best example sir had given. अब आप उस trade secret पे देखिए कि Coca-Cola and Pepsi, we know they are the best competitors, close substitutes. Economics में हम पढ़ाते हैं close substitutes, right? आप सोचिए कि उस trade secret की cost क्या होगी? Can we imagine? क्योंकि पूरा competition उसी पे based है. All the competitive value is based on that trade secret. This I'm skipping. Now, academia, I'm again coming back to academia, that as academicians, why the focus is more on this creativity and innovation. I mean, decades back, we were considering creativity as an artistic talent. And teachers were considered pure teachers for dissemination of knowledge. For generation of knowledge, we consider that it is the task of the scientists. But the roles have become interlinked these days. As academicians, we have always been the creator of knowledge, what we call in simple terms as research. And dissemination of knowledge, which is extension. And if we look at the accreditation aspects, whether the ranking or the accreditation, in both the cases, almost maximum points they are giving for research and extension activities. So this is, I think, first and the foremost thing. I mean, my own intentions, your own intentions, that you want to create something, that is an intrinsic motivation. Nobody is restricting us. But this is an extrinsic motivation or an extrinsic pressure that we should devote time for the research and extension activities. IP-based technology transfer, serving our individual interest as well as the societal interest, societal benefits. In my profile, they have mentioned that I am the judge and trainer for HEC Montreal, Canada. HEC Montreal is amongst the top 50 universities of the world. Though I'm not their ambassador, I'm not promoting them. I'm just mentioning one good thing that they are doing. That's the best practice around the world. That is the only university which is doing a social innovation generation program, which is a 9 months program. And it starts with train the trainers. It's a competition come training program. And their focus is based on the innovations which are of social purpose. And the best prize is in millions of dollars. This much funding they are having. So coming back to this, we also need that sort of innovation ecosystem. And all thanks to the new initiatives that the government of India is taking, like Startup India, Make in India, all these combined together, they are trying to generate a sort of an ecosystem for entrepreneurial development. In the previous session, I believe Sir might have had a discussion on the IPs that can be bought, sold, mortgaged. I just have a brief interaction with him. So from that, I had an understanding that he might be focusing on this, that how this can be used for mortgage purposes, just like we use gold and silver. In the past, there have been several issues which we all are aware, lack of awareness, intricacy, lack of training, and other facilities for which we have not been able to convert those ideas into prototypes Now, with the advancement in the technology as well as advancement in the infrastructure, which we are having at the college level or the university level, I believe it is comparatively easier. I'm not saying it's very easy these days. It's comparatively easier. And the process of filing has also become easy. I remember when I first filed, when I filed the first copyright in the year 2008. That time, there was no provision for online filing. You have to go to the copyright office, and that too, they had a very sarkari sort of system कि आप सिर्फ 2 से 4 के बीच में आएंगे और वो अपने रजिस्टर्स में चेक करेंगे, तब आपकी एप्लीकेशन लेंगे और एप्लीकेशन के बाद आपको स्टेटस पता करने के लिए फिर से जाना पड़ेगा कि उस कॉपीराइट पे क्या हुआ. And these days it becomes so easy कि within few minutes the whole process gets completed. As simple as that. So when we are talking about patents, let us first complete with the patents. Then I'll mention why there is a need for copyright. The UGC, CBCS, earlier in the CBCS, they have implemented generic elective on IPR across all courses. Now in NEP, they are emphasizing so much on IPR. May it be the NIRF ranking or ARIA or any ranking, or you talk about QS ranking or THE, the Indian as well as the global rankings. In each ranking, the maximum weightage is on. For university, if you see in the NAC itself, the highest rating is for research and extension. For institutes, it's more towards teaching and learning, but still the second highest is for research and extension activities. This, I think, might have been covered, the patenting system in India. So I'm quickly skipping. What is patentable and what is non-patentable? Now, this is what I was talking about, provisional application. Suppose I have an idea and I thought, let's first protect it. क्योंकि कल को अगर कोई भी डिस्क्रिपेंसी होगी तो एप्लीकेशन की डेट से देखा जाएगा कि फाइल कब की थी. तो प्रोटोटाइप बनाने के लिए हो सकता है कि बहुत लोगों से डिस्कस करना पड़े. आउट ऑफ दैट डिस्कशन, how would I be claiming that it was originally my idea? We used to hear a lot of stories about it, whose idea it has been. So provisional application gives that coverage. Once you file a provisional application, you'll be getting a 12 months time period. So that 12 months time period is enough to develop a prototype. So that way the protection can take place. What if I'm discussing my idea with an attorney through which I want to file an application? उस पे कैसे trust किया जाए? With a non-disclosure agreement? Again, that is important. It sounds simple, but that is important. आप कैसे भरोसा कर सकते हैं? इतनी मुश्किल से तो ideas आते हैं. It's not that easy. There is a difference, daydreaming and ideas. इतनी मुश्किल से इतने सारे dreams में से कुछ एक ideas होते हैं. I mean, out of all the thoughts that we have, some are ideas. And those some, it's not easy to discuss it with anyone, any random person. And that too, वो attorney तो खुद law के जानकार होंगे. तो उन्हें तो खुद पता होगा कि how to protect it.
It's a provisional application condition. अगर आपके लेकिन नॉर्मली फार्मा में आपको पहले से आप एक्सपेरिमेंट वहां एक्सपेरिमेंट बेस्ड होते हैं, तो वहां पहले आपने कुछ एक्सपेरिमेंट किया होगा, अगर आपको लग रहा है कि इसका रिजल्ट निकल रहा है, देन ओनली यू विल थिंक ऑफ, क्योंकि होने को रिजल्ट आपका इमीडिएटली निकल जाए, कॉम्पोजिशन मिक्सचर नहीं निकलने को, तो वहां जनरली आपके केसेस ही वो उस केस में आप डिसाइड करोगे जब आपके पास कोई सॉलिड वो होगा, राइट? बिकॉज दैट्स नॉट मेयरली बेस्ड ऑन एन आइडिया, that's an experiment.
So all these are advantages of provisional application. There are always advantages and disadvantages. It's up to us to take decision what to do, whether to go for a provisional application or not. Then there is another category, ordinary application or the non-provisional application. You can directly go for a non-provisional application also. It's not necessary that you need to follow that step of provisional application. And then we have a conventional application, priority date based. Then PCT international application. Is it been covered in the previous session or shall I take it? Okay. This is basically for the problem which we face that, okay, I am having an idea, I want to get it protected. Now, which country, how can I decide? Just because I'm a resident of India, I need to file an application in India. What about its protection in other countries? How to decide that how many countries shall I go for? So this is basically a PCT application. It is an international application governed by the Patent Cooperation Treaty. That is the full form of PCT. And it can be validated up to 142 countries. 142 is the figure which I have taken, right? It may vary. These are some of the advantages of a PCT application. I mean, within a single application, you are having a claim in multiple countries. So that's the biggest advantage of this application. This is a single international patent application can be filed in order to seek protection for an invention in up to 142 countries throughout the world. And the priority date obtained by filing this application is internationally recognized. This is beyond the territorial jurisdiction which we were talking about and has an effect in each of the countries. It gives the application 30 to 31 months to enter into various countries from the international filing date or the priority date. So this is providing more time to assess the viability. So now the options are available. It's up to us that what are our requirements, and based on our requirements, what provisions we want to have. Let me switch over because I believe a little break is required. So instead of a break, let me proceed to a case study. I hope you'll find it more interesting rather than this. So this is all about the PCT application. All this information is available on the website. You can have all the information from that. And then we have organizations like WIPO, which is providing a lot of awareness. You will find a lot of awareness videos on that, which makes it comparatively easy to understand. Patent of addition we have divisional application. So all these we need to decide based on our requirements. In India, if I particularly talk about, the application can be filed either alone or jointly by any person claiming to be the first inventor or inventors, by any person being the assignee of a person through the attorney that I was mentioning, legal representative or any deceased person or assignee. Physical filing, then we have e-filing system. The documents required, I'm just skipping. All this is available on the website. the steps involved. The first and the foremost is you need to decide whether you are going to do it yourself or you're engaging. Right. Now, for taking this decision, the most important factor is to consider the number of deadlines. Whether as an individual, if you are filing, you'll be able to meet those deadlines or not. So based on this, we used to decide that whether if I am able to meet all those deadlines, it's pretty good to file on your own. But if we believe that we may or may not be able to meet those deadlines, so it's better to take the services of an attorney. And another thing is claims. If we are good at understanding those technical terms, playing with the words, it's always easy to get it filed on our own. But if that is not the case, we need to go for the services because they are experts in that. Then, of course, if we are looking for expert support or services, comes the role of a non-disclosure agreement, which is a must. Check the patentability of the invention by performing a search for similar technologies. This is the preliminary search, the patent search. That whatever idea you have, just like a Google search, Google is a database which is providing searching options, right? Whatever we want to, like for example, I want to write a research paper. The first thing I'll do is review the literature, that whatever I'm thinking of, how novel it is. Is there anyone who have done similar sort of research? So the first and the foremost thing, I'll be doing a literature review and identifying a gap, doing a gap analysis. And on the basis of that gap, where that gap exists, that will become a foundation stone for my objectives. That because there is a gap in the literature, these are the areas on which nobody have researched. Now, this can be a research topic for me. This can become my research objectives. So same way, in case of patents also, we go for a patent search. कि उससे related कितने patents हुए हैं और हुए हैं किन-किन countries में हुए हैं. Gap आपका सिर्फ idea में नहीं होता, gap आपका geographical locations में भी होता है. Of course, then drafting the patent application, either you are going for a provisional application or a complete application. The first filing in India or foreign filing decision, again, that's a decision to make. Then the publication of the patent application. Examination, request for examination, all these are the steps. Examination process, the objections, final decision and the renewal. Now, these are some of the things we already covered, like not using non-disclosure agreements, not searching for prior art, right? These are the things which we need to avoid because again, the cost is involved, the time is involved. So we are not permissible. I mean, these kind of mistakes are not permissible. Filing a patent application at the wrong time. Now, who will tell what is the right time for the patent application? Are we talking about some auspicious time कि पंडित जी कोई time देख के बताएंगे कोई अच्छा मुहूर्त जिसमें patent application file की जाए? Of course not. Generally, they say inventors develop and take a product or service to market to see if the product or service is viable. The time is in that context we are talking about, the viability in the market, and then think of applying for the patent. Now that viability can be checked after filing a provisional application, we will be getting a 12 months time period. That 12 months time period is sufficient to check the viability of the product. Isn't it? Because in the process of checking the viability of the product, somewhere or the other, you are sharing your ideas with others. And every single person, you cannot enter into a non-disclosure agreement. So that's why it's suggested taking advantage of the provisional application. Filing a poorly drafted application when we are not sure that what claims we need to have. Sometimes because we are not technical experts, we are not able, the idea may be very, very good, but we are not able to actually claim all the things. So a proper drafting is equally important. And commercialization of patents, that was the data I was talking about in the beginning. According to a Forbes report, out of the 2.1 million active US patents, hardly 5% have reached the market. I've specifically taken figures from the US because we normally compare that in US we have academics-led industry. What they are researching in the academics is seeing the market. Whereas in India, it's a completely different scenario. We are running industry-led academics. So if we see the figures of US, out of the 2.1 million active patents, active, that doesn't require renewal. They are talking about the active patents. Hardly 5% reach the market. About 90% of the patents fail to be commercialized or find angel investors, whatever may be the reason. These unlicensed patents include over 50,000 high quality patented inventions belonging to universities. So they also have a similar scenario. Yes, sir. So 86%. Now try to estimate. If we look at the figures, I mean, if I fetch from the public domain, if I fetch their balance sheets and see their R&D budget, which is huge. Now 86% of that R&D budget goes in vain. And that too with companies like IBM, who are very choosy in recruiting people. I mean, these are the repercussions. They say similarly in India, no more than 5% of patents reach the market. We too had a similar story. However, commercialization rate of China is too high, 34.7%. And we can rely on this data. First thing is it's provided by Forbes. And second thing is we ourselves see in the market the Chinese products. Now, this is the big question in commercialization. That why is it so that, and we are not talking about mere ideas. We are talking about, we are comparing these figures for those patents which are granted. You take example of any university which are claiming, any university, any institute, which are saying we have these many patents. Every single information is there in the public domain. If we check, the figures are misleading. Misleading in the sense, all those are not granted. There is a small star mark. It contains the published ones also.
China is the production house of the world. That's why I think that patent, whatever they are getting, they are utilizing in their commercialization. And I think that number of patents what is filed in China is much more than US, or 2 times more than US.
And same figure, I'm giving you another factor also, right, which also cross validates this figure. You see the number of Chinese students in European universities, especially US, UK, Australia, the number of Chinese students and the kind of research they are doing. The main focus is on research. Of course. They're better in what context? It's not only research they are focusing on. Indians are doing, I mean, I'm also a proud Indian. Indians are doing better in all aspects. You see Fortune 500 list of companies. The top ranking positions are being held by Indians. You see universities and the colleges abroad. Their deans, whether it's the Oxford Said Business School, their dean is an Indian, right? Plenty of examples. So that way we are very good. But we are comparing in terms of research focus. Yes, sir.
I think ownership of those companies should divide.
Very true, sir. I think with initiatives like Make in India and our young generation, I believe you are the students, right?
See the day where the ownership,
These companies, I mean,
the owner are not Indians.
we should be the host countries for these companies, right? And that is possible when we would be having an entrepreneurial spirit in our youth. And that entrepreneurial spirit will obviously come through innovation. Right? Very true, sir. That's it, I think, our dream for every Indian. Now, this is the case I was talking about. Ma'am, how much time is left? Just 5 minutes, I can write? Okay, already. This is the commercialization of an invention before the grant of a patent. Hard to digest, क्योंकि patent होने के बाद नहीं commercialization हो पा रहा. But there are stories जहां patent होने से पहले commercialization हो गया. So very quickly, I'm just going through. It is the story of an Indian inventor who was a freelance consultant when he conceived the design of this MHRU, Matrix Heat Recovery Unit. And this invention was related to heat exchanger. So all this, you can quickly have a look. This exchanger can basically recover heat from the hot gases or the vapors from the engines, gensets, boilers, furnaces. So in late 1990s, this idea was actually introduced to Unidyne Energy Environment Systems Private Limited by one of their friends, which is a small scale company. I mean, that time it was a small scale company based in Mumbai, and they were manufacturing and selling direct waste heat fired boilers and various other industrial thermal energy systems. So they had given a demonstration of the invention to the company. They signed a memorandum of understanding with the company by which a license was granted to that particular company to manufacture and sell the MHRU, which their original idea was, as engine exhaust fired steam generators and water and thermic heaters. As per the MOU, down payment was also there at the time of signing, and subsequent payments were made at regular intervals. So this is another way, if we are able to actually sell the idea, right? Consider it like a construction linked plan. बिल्डर घर बनने से पहले बेच दे रहा है और हमने घर सिर्फ प्रोटोटाइप में देखा है. इट्स अ सिमिलर थिंग. बट यहाँ हमें श्योरिटी है कि घर मिलेगा, राइट? वहां उन्हें श्योरिटी है कि इन्वेंशन विल टर्न इनटू अ प्रोटोटाइप. और जो प्रॉब्लम थी फंडिंग वाली, वो भी सॉल्व हो गई, राइट? यूनिडाइन के लिए अगेन विन विन सिचुएशन थी कि उनके पास एक नई इन्वेंशन आने वाली थी. और अभी जो सर ने आईबीएम वाला एग्जांपल दिया, आर&डी कॉस्ट, किसी भी कंपनी के लिए आर&डी कॉस्ट कंपैरेटिवली हाई होगी, टेक्नोलॉजी ट्रांसफर की कॉस्ट उसके बराबर थोड़ी हो जाएगी. आप लाइसेंसिंग एग्रीमेंट में जा रहे हो, आप टेक्नोलॉजी ट्रांसफर में जा रहे हो, ऑफ कोर्स द कॉस्ट विल नॉट बी हायर देन द R&D budgets. So they filed a provisional patent in 1999 after the successful demonstration of the invention to Unidyne, and this invention was licensed on the basis of the patent application, and all the cost of patent filing and maintenance were borne by the Unidyne. The first examination report was received in early 2004. I'm mentioning the figures because that demonstrates that we need to have patience. It is a matter of years. The patent agent was changed mid-course and the patent specification, again, there was a twist कि बीच में patent agent change हो गया. Specification में claims amend किए गए. After a hearing and few office actions with the patent examiner, the patent was finally granted in 2004. The patent was not assigned to Unidyne. Unidyne ने पैसा दिया, सब दिया, but the patent was not assigned to Unidyne. Inventor was the same person. It was agreed that the technology would not be licensed to any other company. Mutual exclusive rights Unidyne को दे दिया कि किसी और कंपनी को ये टेक्नोलॉजी ट्रांसफर नहीं की जाएगी, इसके राइट्स नहीं दिए जाएंगे. The rights will be borne by, but the original inventor will remain the original inventor. क्योंकि रॉयल्टी भी तो आगे मिलनी है. What if they are not paying the royalty? तो वहां उनके पास राइट्स होने जरूरी हैं. So only the protection is not necessary. We need to be aware of our own rights also. So I think I had already taken a lot of time. So hope I have been able to communicate, add on to some knowledge. You have been a wonderful audience. I really enjoyed, right, interacting with you people. Thank you so much for sparing your valuable time. And as I mentioned in the beginning, that it's not a it's not a one-way communication. At the end of the day, I'll also be learning a few aspects, like sir have very rightly mentioned. Sir had a great discussion. Thank you so much.
Thank you, ma'am. Your talk on introduction to IPR and its uses for academics, easy filing of patents and copyright, and their commercialization was inspiring and left us feeling motivated. Now, I would like to call HOD sir, Dr. Anu Chaudhary, for presenting a gift to Dr. Ruchika Gupta as a token of thanks. Thank you, sir. As we approach the culmination of our program, I would like to call upon the stage our fifth speaker and the last speaker of the event, Advocate Divesh Agarwal. Divesh Agarwal is a lawyer practicing mainly in trademarks and other intellectual properties. Hailing from Jhansi district, Divesh completed his schooling from Christ the King College and Cathedral College in Jhansi. He pursued his higher education at Bundelkhand Degree College, where he obtained his BCom, MCom, and LLB degree. Coming from a business family background, Mr. Agarwal was exposed to the intensity of entrepreneurship from an early age. It was during his graduation that he recognized the pressing need for intellectual property security in business, particularly in Jhansi and Bundelkhand region.
आपका नाम क्या है? ओके सबसे पहले जो है मैं अजय कुमार गर्ग इंजीनियरिंग कॉलेज और यहाँ के जो वो कार्यक्रम संयोजक हैं मैडम सोनम गुप्ता मैम, उनका बहुत धन्यवाद दूंगा कि उन्होंने मुझे इस इवेंट का हिस्सा बनने का मौका दिया। ठीक है, और अभी चूंकि सेशन में थोड़ा सा ही टाइम बचा है, फर्स्ट ऑफ ऑल आई विल जस्ट रिव्यू कि आज क्या क्या यहाँ पर हुआ है। यहाँ पर जो सबसे पहले है, आप लोगों को समझ में आया होगा IPR क्या है। वो प्रॉपर्टी, वो इंटेंजिबल एसेट जो हमारे जो दिखती नहीं है, एक प्रॉपर्टी जो दिखती है वो जो दिखती नहीं है, ये इसमें से जो है बेसिकली जो है जो रजिस्ट्रेबल होती है वो पांच प्रकार की होती हैं। आपके ट्रेडमार्क, एक व्यापार चिन्ह बोलते हैं उसको, ठीक है, आपका पेटेंट्स हो गए, ठीक है, और कॉपीराइट्स हो गया, डिजाइन हो गया, और जो GI हो गया। ठीक है, अब मैं जो यहाँ पर अभी खड़े थे, क्या नाम था उसका, आपका नाम क्या है? राघव अग्रवाल। जब मैं आया था सबसे पहले इन्होंने कहा था वैलिडिटी ऑफ IPR। ठीक है, ये बहुत इंपॉर्टेंट मुद्दा है। ठीक है, लोग सोचते हैं कि IPR जो है बहुत लंबे समय तक, मतलब कई वैसे वो टाइम बेस्ड होता है, उसमें लिमिटेशन होती है, लिमिटेशन बाय रीजन एंड लिमिटेशन बाय टाइम। ठीक है, तो लिमिटेशन बाय रीजन एंड लिमिटेशन बाय टाइम, तो जितने भी अपने IPR होते हैं बेसिकली इनके सबका जो है टाइम का लिमिटेशन होता है। फॉर एग्जाम्पल पेटेंट इज वैलिड फॉर 20 ईयर्स। कंट्री टू कंट्री थोड़ा बहुत डिफर करता है, लेकिन सिंस मोस्ट ऑफ द नेशंस आर पार्ट ऑफ इंटरनेशनल ट्रेड अग्रीमेंट्स, तो उनका लगभग सेम रहता है। ठीक है, डिजाइन जो है पहले 10 साल के लिए होता है, 5 साल के लिए एक्सटेंड हो जाता है। ट्रेडमार्क जो है इन्फिनाइट पीरियड के लिए होता है, लेकिन आपको हर 10 साल में जो है पैसे देने पड़ेंगे सरकार को। मतलब आप सोचें कि आप ओनर बन जाते हैं तो पूरी तरह से ओनर नहीं बन पाते आप, आपको एक तरह से पट्टा मिल जाता है, जमीन का जैसे पट्टा होता है ना, आप सरकार के पास जाते हैं प्रपोजल लेके कि हम ये करेंगे और मतलब इस तरह का डेवलपमेंट करेंगे, और सरकार आपको उस जमीन का इस्तेमाल करने का राइट दे देती है। तो ये पट्टा होता है, उसकी आपको रेगुलर फीस, आप 10 साल बाद पैसे नहीं देंगे, सरकार कहेगी जाओ भैया ये तो पब्लिक डोमेन में आ गया। ठीक है, उसके बाद GI है, GI का 10 साल का टाइम पीरियड होता है, और कॉपीराइट होता है आपका लाइफ ऑफ ऑथर। ठीक है, लाइफ ऑफ ऑथर, और उसके बाद प्लस 60 ईयर्स। ये इंडिया में अलग अलग कंट्रीज में अलग अलग सिनेरियो होता है। ये किसका है? ठीक है, अब जो मेरा बेसिक जो हमारा जो डोमेन है वो ट्रेडमार्क का है, तो पहले मैं ट्रेडमार्क के बारे में थोड़ा सा संक्षिप्त में बोलूंगा। ठीक है, कि क्योंकि अभी यहाँ से आए हैं सारे, ज़्यादातर लोग जो हैं इंजीनियरिंग और आपके रिसर्च से रिलेटेड लोग ही आए हैं जब से मैं आया हूँ। ठीक है, तो ट्रेडमार्क बेसिकली ये क्या होता है, आप बताइए, क्या आप किस तरह से ट्रेडमार्क किन किन चीज़ों का ले सकते हैं, कोई बता पाएगा? ट्रेडमार्क बेसिकली है क्या? आप ट्रेडमार्क का जो है ठीक है, एक आम भाषा में बोले कि कोई भी साइन, सिंबल, इंडिकेशन जो एक व्यक्ति का प्रोडक्ट और सर्विसेज को दूसरे की प्रोडक्ट और सर्विसेज से डिस्टिंग्विश कर सके। ऐसा नहीं है कि ट्रेडमार्क सिर्फ लोगो का होगा या वर्ड का होगा, ट्रेडमार्क एक शेप का भी हो सकता है, कलर का कॉम्बिनेशन भी हो सकता है, इवन स्मेल भी हो सकता है। ठीक है, स्मेल मैं बता दूं मैकडी के पास है स्मेल के ट्रेडमार्क्स। ठीक है, आप जाएंगे मैकडी में तो कभी आपको जनरली उनके अलग तरह की हल्की सी वो सुगंध आती है उनके यहाँ। ठीक है, सॉसेस की, तो वो उनका जो है स्मेल बेस्ड ट्रेडमार्क है। ठीक है, अब एक
जब आप इनोवेशंस करते हैं, ये सारी तो चीजें हो गई, ठीक है, लेकिन व्हेन इट कम्स टू रियलाइजेशन टू रिटेल मार्केट, जब आप रिटेल में जाते हैं तो आपकी टेक्नोलॉजी जो है उसको भुनाने के लिए आपको एक नाम की जरूरत पड़ती है, कोई इंडिकेशन की जरूरत पड़ती है, वो होता है ट्रेडमार्क। ठीक है, अब ट्रेडमार्क के क्या होता है कि नॉर्मली हमारे यहाँ क्या दिक्कत होती है कि लोग जो हैं ट्रेडमार्क में जो इन्वेस्ट करते हैं, व्हाट दे डू, दे ट्राई टू डू बिजनेस इन जो कॉमन शब्द होते हैं। ठीक है, एक्चुअल में पॉलिसी होनी चाहिए कि वो जो वर्ड है वो एकदम फैंसीफुल होना चाहिए, इनोवेटिव होना चाहिए। ठीक है, मीनिंगलेस, बेटर इज मीनिंगलेस, मीनिंगलेस भी होना चाहिए। ठीक है, हम नॉन डिस्टिंक्टिव शुड नॉट इंडिकेट एनी कैरेक्टरिस्टिक। ठीक है, कैरेक्टरिस्टिक होगा तो फिर कल हमारे देश में लॉ है कैरेक्टरिस्टिक वाले, जो अगर आपके प्रोडक्ट को की कैरेक्टरिस्टिक या लोकेशन के बारे में जो बता रहा है, ठीक है, ओरिजिन के बारे में, ये ठीक है, तो या काइंड या प्रोडक्ट को खुद डिफाइन कर रहा है, जो डिस्क्राइब कर रहा है प्रोडक्ट को, वो आपको नहीं मिलता। तो सबसे बड़ी गलती हमारे यहाँ के लोग करते हैं कि वो ऐसे मार्क लेते हैं जो कि उस प्रोडक्ट को डिस्क्राइब करते हैं। यहाँ पर सबसे बड़ी गलती, आप जब भी कोई काम करें, ठीक है, ऐसा नहीं है आप बिजनेस स्टार्ट कर रहे हैं, ठीक है, आप जैसे आपने कोई प्रोडक्ट बनाया, आप बिजनेस स्टार्ट कर रहे हैं, तो आप पहले कोशिश करिए अप्लाई फॉर 2 और 3 मार्क्स, क्योंकि अगर वो जो ऑब्जेक्शन आता है तो इट टेक्स टाइम ऑफ, अगर विभाग से आपत्ति आती है तो कम से कम 2 साल बाद तो आपकी हेयरिंग ही आएगी। अगर किसी दूसरे पक्ष ने आपत्ति कर दी तो 6-7 साल लग जाते हैं। ठीक है, तो एक तो ये स्ट्रेटेजी हो गई। अब दूसरा मैटर क्या होता है कि जब जो हमारे यहाँ जो ज़्यादातर ट्रेडमार्क के जो स्टेक होल्डर्स होते हैं, उनका मेन एम क्या होता है कि भाई हमारा एक छोटा सा एम होता है कि हम अपने क्षेत्र में किसी को कॉपी नहीं करने दें। लेकिन होता क्या है, जब वो 10-20 साल बाद उनका जब बिजनेस बड़ा हो जाता है, एट दैट पॉइंट ऑफ टाइम दे रियलाइज यार हमारे तो लोगों ने मिलते जुलते बहुत ब्रांड कर लिए और वहां पर हम नहीं लड़ पाते हैं। ठीक है, इसलिए मैंने कहा कि कोई भी ऐसा मार्क नहीं आप अपने बिजनेस में लाइए जो कि, क्योंकि आपने सपोज कोई डिस्क्रिप्टिव मार्क लिया, ठीक है, उस पर आपको एक्सक्लूसिव राइट तो मिलेगा नहीं। ठीक है, उसमें कुछ ना कुछ कंडीशन रिस्ट्रिक्शन डाल देंगे, उस रिस्ट्रिक्शन को लेकर दूसरा बंदा रजिस्टर करा लेगा। ठीक है, अब हम जो आते हैं, चूंकि सेशन बहुत शॉर्ट है, ठीक है, तो आपका जो एम है ट्रेडमार्क के मामले में, एक तो आपका मार्क अलग होना चाहिए, दूसरा आपका एम होना चाहिए, आपका जो नाम है वो आपको रजिस्ट्रेशन मिलता है प्रोडक्ट वाइज। ठीक है, प्रोडक्ट वाइज मिलता है, आपको एक्सक्लूसिव राइट हर चीज के लिए नहीं मिलते, अनलेस एंड अनटिल इट हैज अक्वायर्ड वेल नोन स्टेटस। हमारे देश में जो है आज से 4 साल पहले तक कुल मिला के 81 मार्क थे वेल नोन डिक्लेयर्ड। ठीक है, रिसेंटली अभी पिछले महीने 150 मार्क और भारत सरकार ने डिक्लेयर किए। ठीक है, वेल नोन, तो आपको वेल नोन स्टेटस पे जाना पड़ेगा। उसके लिए आपको प्रोडक्ट भी अच्छा होना चाहिए, मार्केटिंग भी अच्छी होनी चाहिए, जिससे कि मतलब आपका जो ट्रेडमार्क में जो टारगेट होना चाहिए ना, वो यही होना चाहिए। और प्लस कोशिश करिए कि ऐसा मार्क लें जो कि मैक्सिमम क्लासेस में क्लियर हो, भले ही आप अपने प्रोडक्ट के लिए उसे अप्लाई करें। अब ये तो हो गया ट्रेडमार्क का। ठीक है, अब जो कि मेरा जो बेसिकली टॉपिक था कि जो ओवरऑल आईपीआर होती है, ठीक है, वो तो ना सिर्फ एक इंडिविजुअल के बेनिफिट के लिए होती है, वो ओवरऑल नेशन के बेनिफिट के लिए होती है। ठीक है, आप सोच सकते हैं कि आईपीआर में किन किन लोगों को बेनिफिट होता है। जो आपके व्यापार चिन्ह हैं, नवाचार हैं, कॉपीराइट है, ठीक है, इनके पंजीयन और इनके डेवलपमेंट से किन किन लोगों को इनकम होती है। आपके गवर्नमेंट ऑफिस में एग्जामिनर्स होते हैं, ऑफिसर्स होते हैं पेटेंट ऑफिस में, ठीक है, पेटेंट एजेंट्स को एम्प्लॉयमेंट मिलता है, आईपी एडवाइजर्स को एम्प्लॉयमेंट लेता है। आजकल आईटी फर्म्स और एआई भी इसमें इन्वॉल्व हो गए हैं, ठीक है, फॉर सर्चिंग एंड डेटा मैनेजमेंट। ठीक है, लॉयर्स को जॉब मिलती है, पेटेंट ड्राफ्टिंग स्पेशलिस्ट होते हैं, पेटेंट एनालिस्ट होते हैं, और जो है आपके रिसर्चर्स होते हैं। सबसे ज़्यादा एक ऐसा सेगमेंट है जिसको आईपीआर डेवलपमेंट में
इंडस्ट्री में इतनी इंपॉर्टेंस नहीं मिलती, वो है हमारे टीचर्स। हमारे टीचर्स जो किंग मेकर होते हैं, वो पढ़ाते हैं, बुक्स भी बनाते हैं, बुक्स टाइप, वो ऑथर भी होते हैं, लेकिन उनको सिर्फ लिमिट ये कि हाँ इनने बुक बनाई, लेकिन एक्चुअल में क्या है कि जो हमारे इंजीनियर्स वगैरह हैं वो उन्हीं बुक्स से पढ़ के ही इनोवेशन करते हैं। ठीक है, तो इसमें क्या है कि ओवरऑल बहुत सारे लोग इन्वॉल्व हो रहे हैं, तो चूंकि जब रेवेन्यू बढ़ेगा तो देश का विकास होगा। दूसरा क्या है, जब हमारे जो देश में इंटेलेक्चुअल प्रॉपर्टी का विकास होगा, मतलब विकास डेवलप होगी, जनरेट होगी, जितनी ज़्यादा जनरेट होगी, ठीक है, वो उतने ही हमारे देश के ओवरऑल जो हमारे देश के जो प्रोडक्ट्स हैं, ठीक है, उनके इंटरनेशनल मार्केट में डिमांड बढ़ेगी। ठीक है, और इंटरनेशनल और लोकल मार्केट में भी। ठीक है, जब आपके पास अच्छा प्रोडक्ट होगा, अच्छी टेक्नोलॉजी होगी, ठीक है, तो आप लोगों से ज़्यादा पैसा ले सकते हैं। ठीक है, इसी प्रकार अगर आपका प्रोडक्ट आपके देश में, मतलब ओवरऑल मैं बता रहा हूँ, जैसे हमारे देश जो है, अभी मैं एक रिपोर्ट पढ़ रहा था, मैम ने बताया कि चाइना जो है, किसी ने बोला था कि चाइना एट प्रेजेंट जो है सबसे ज़्यादा एक्सप्लॉइट करता है आईपीआर को। ठीक है, लेकिन यहाँ पे जो मैंने आज पढ़ा है, कोई जर्नल पढ़ रहा था, इस साल जो है इंडिया, हमारा देश भी जो है, परसेंटेज ग्रोथ की बात कर रहा हूँ मैं, फिगर्स की बात नहीं, परसेंटेज ग्रोथ इन आईपीआर हमारा देश इस वक्त सेकंड नंबर पे आ चुका है। ठीक है, मुझे पता नहीं है वो रिपोर्ट ऑथेंटिक है, आफ्टर चाइना उसमें लिखा हुआ था। ठीक है, अब इसके बाद जो है दूसरा क्या है कि जो टेक्नोलॉजी जो होती है आपकी, उससे कॉस्ट कम होती है, कॉस्ट कम होती है तो इंटरनेशनल मार्केट में हम कॉम्पीट कर पाते हैं। ठीक है, अगर हम कॉम्पीट कर पाएंगे तो इससे हमारे एक्सपोर्ट्स बढ़ेंगे और ओवरऑल हमारे देश का रेवेन्यू बढ़ेगा। ठीक है, टेक्नोलॉजी दैट इंक्रीजेज एंड डेवलप्स क्वालिटी एंड यूजेबिलिटी ऑफ प्रोडक्ट, जो कुछ जो टेक्नोलॉजी है वो ओवरऑल क्वालिटी एंड यूजेबिलिटी बढ़ा रही है। कि मैम ने बोला कि इनोवेटिव, अभी मैम ने बोला था, ठीक है, कि अगर वो तो क्या कहते हैं, आप कुछ उसमें अच्छा हो रहा है, कॉस्ट कम कर रही है या उसकी यूजेबिलिटी बढ़ा रही है, तो आपके प्रोडक्ट का वो ऑटोमेटिकली वैल्यू मार्केट में बढ़ेगी, उसकी डिमांड बढ़ेगी। डिमांड बढ़ेगी तो सिर्फ आपका रेवेन्यू नहीं बढ़ेगा। ठीक है, ओवरऑल नेशन का रेवेन्यू बढ़ेगा और सरकार का भी रेवेन्यू बढ़ेगा। आप कमाएंगे ज़्यादा तो सरकार के पास भी जाएगा। ठीक है, आपसे जुड़े हुए जो एम्प्लॉयज़ हैं वो भी कमाएंगे। ठीक है, डिमांड जो आपका आईपी है, ठीक है, सबसे बड़ा जो बेनिफिट है इनोवेशंस का वो ये है कि लाइफस्टाइल सुधरती है। जो मेन पर्पस है आपके इंटेलेक्चुअल प्रॉपर्टीज का और आपके इनोवेशंस का, वो है हमारे मानव का जो जीवन शैली है वो सुधारने का। ठीक है, अगर आपके इनोवेशंस, मतलब कुछ इनोवेशन जो युद्धों में इस्तेमाल होती हैं, ठीक है, तो वो डिस्ट्रक्टिव, लेकिन हमारा एम जो है मेनली, जो सबसे बड़ा एम होता है आईपीआर का, वो सोशल और जो है ओवरऑल जो क्या है सोशल सिक्योरिटी बढ़ाने का होता है। ठीक है, और जैसे एक तो ईजीमेंट हो गया, अब आपने दवाइयों में आपने इन्वेस्ट किया, ठीक है, दवाई जो है इन्वेंशंस आपने डेवलप की, ठीक है, तो वो उससे भी जो है आपकी हेल्थ सेफ्टी और फिजिकल सिक्योरिटी उसको भी बढ़ावा मिलता है। ठीक है, इंटेलेक्चुअल प्रॉपर्टी प्रोटेक्शन increases international trade since it can be used to restrict people of other nations to copy your product। ठीक है, ना सिर्फ हम अपने सिनेरियो में नहीं देखेंगे, दूसरे देश के लोग हैं जिन्होंने हमारे देश में पेटेंट फाइल करा रखा है, ठीक है, तो हम उनके प्रोडक्ट भी कॉपी नहीं कर पाएंगे। ठीक है, और जो हमारे देश के लोग हैं जिनको दूसरे देशों में पेटेंट ग्रांट हो चुका है, उस देश के लोग हमारे देश के प्रोडक्ट्स को कॉपी नहीं कर पाएंगे विदाउट लाइसेंसिंग। ठीक है, तो इससे क्या होगा कि दे विल बी फोर्स टू परचेज गुड्स फ्रॉम ओरिजिनेटर, जो ओरिजिनल जो जहाँ से ओरिजिन हुआ है प्रोडक्ट का वहाँ से, तो उससे इंटरनेशनल ट्रेड को बढ़ावा मिलता है। ठीक है, अब आती है ब्रांड की बात। ठीक है, तो ब्रांड बेसिकली हम जब ब्रांड को डेवलप करते हैं तो डेवलपमेंट में आपका एक तो प्रोडक्ट की क्वालिटी होती है, ठीक है, दूसरा होता है एडवर्टाइजमेंट। अगर एडवर्टाइजमेंट आप कैसे मार्केट कर रहे हैं, अगर आप अपने प्रोडक्ट को अच्छा दिखा के मार्केट कर रहे हैं तब भी आप रेवेन्यूज जनरेट करते हैं, ठीक है। अगर आपका प्रोडक्ट अच्छा है तो लोग आपको कीमत ज़्यादा देंगे, ठीक है। अगर दूसरा जो है ब्रांड का यूज़ होता है, हम सस्ता है, ठीक है, चीप प्रोडक्ट की अगर हम इमेज डेवलप करते हैं तब भी आपको बेनिफिट होता है, क्योंकि आपकी क्वांटिटी ऑफ सेल्स बढ़ती है। आप समझ रहे हैं ना, ठीक है। और आपकी क्वांटिटी ऑफ सेल्स बढ़ जाती है। और इसके इसके अलावा एक जो सबसे बड़ा बेनिफिट, अब ट्रेडमार्क से हटके थोड़ा सा मैं बोलूँगा, ठीक है, जो लिमिट होती है आपके पेटेंट्स डिज़ाइंस वगैरह की, इसका सबसे बड़ा बेनिफिट होता है कि जो उनकी एक्सपायरी के बाद दैट टेक्नोलॉजी दैट डिज़ाइन बिकम, वो खुली किताब हो जाती है, कोई भी उसको इस्तेमाल कर सकता है। होता क्या था कि पहले के ज़माने में क्या होता था, मैंने कुछ बनाया, मैं सोचूंगा मेरा एक छत्र राज है रहेगा और मैं अपने बच्चों को सिखाऊंगा, ठीक है। सपोज वो चेन ब्रेक हो गई, वो नॉलेज आगे ट्रांसफर नहीं हो पाती थी। अब पेटेंट के जरिए पेटेंट हुआ, डिज़ाइन है, जो रजिस्ट्रेशन है, ये जो आपकी डॉक्यूमेंटेशन जो पब्लिक डोमेन में आ जाती है, ठीक है। तो पब्लिक डोमेन में चूंकि वो आ जाती है 20 साल बाद या 15 साल बाद, जो भी उसकी वैधता है, उसके बाद वो जनरल पब्लिक के यूज़ में आ सकती है, ठीक है। अब आपको जो है एक्सपायरी के बारे में मैंने बता ही दिया है। अब कोई अगर ट्रेडमार्क से रिलेटेड कोई क्वेश्चन हो आप लोगों का तो आप लोग पूछ सकते हैं। बेसिकली एक और मैं बोलूँगा, मैम ने बोला था, कौन सी मैम थी, रुचिका मैम, ठीक है। रुचिका मैम ने अभी एम्फेसाइज किया था कि फिगर्स पे कि कितने जो हैं पेटेंट जो हैं फाइल होते हैं और लेकिन वो ग्रांट नहीं होते, ठीक है। तो फाइलिंग के मामले में बहुत अच्छी न्यूज़ है। 2022 के मुकाबले हमारे देश में इस वर्ष 2023 में 2022 में पर डे का जो पेटेंट फाइलिंग का जो की फिगर्स थी वो 156 थी। इस साल 300 की फिगर रही है, ठीक है। और लेकिन जो ग्रांट हुए हैं 2021-22 में 66,440 जो हैं आवेदन हुए, ठीक है। और उसमें से लेकिन ग्रांट हुए कुल 30,000, मतलब आधे से भी कम, आधे से भी कम। उनमें से भी ज्यादातर ऐसे होंगे जिनकी प्रोडक्टिविटी होगी ही नहीं, ठीक है। एग्जामिनेशन हुए उसमें से लगभग 35-36,000 के करीब जो है उन्होंने डिस्पोज कर किए थे, ठीक है। तो जो है मेन, जो मैम ने बोला, इनोवेशन, इनोवेटिव होनी चाहिए हमारी इन्वेंशन। जो मेन सिनेरियो होता है, चाहे ट्रेडमार्क हो, चाहे आपका डिजाइन हो, चाहे आपका पेटेंट हो, लोग क्या है दूसरे की चेप के, जो दूसरे देशों में जो काम कर रहे हैं उनका जो है उनका आइडिया, उनका प्रोसेस चेप के जो उनका रजिस्टर्ड है उसमें थोड़ा सा परिवर्तन करके अपने जुगाड़ ला के रजिस्टर कराने का प्रयास करते हैं, ठीक है। अब जो है इसमें मैं जो है ट्रेडमार्क की फिगर्स तो बताने की ज़रूरत नहीं है, ट्रेडमार्क तो सबसे ज़्यादा आवेदन होते हैं, ठीक है। मैं बता रहा हूँ तो जो है 2021-22 में कुल जो है ट्रेडमार्क की जो वो हैं एप्लीकेशन 4,47,805 आवेदन आए थे, ठीक है। जिसमें 2,61,408 आवेदन जो हैं पंजीकृत हुए और 3,18,800। आप एक बात, मतलब इसमें मैं इसलिए बोल रहा हूँ कि जो आवेदन जो ग्रांट हुए और डिस्पोज हुए, दिस इज द फिगर ऑफ द ट्रेडमार्क रिजेक्टेड, ठीक है। सिमिलरली जो मैंने आपसे बोला था ना कि इतने ग्रांट हुए पेटेंट में, ठीक है। तो पेटेंट में जो है पेटेंट में 64,000, जिस वर्ष 66,000 66,000 आवेदन आए थे, कुल 30,000 आवेदन जो हैं वो ग्रांट हुए और 35,000 डिस्पोज हुए। इसका मतलब कम से कम 5,000 आवेदन जो हैं वो निरस्त कर दिए गए। अब मैं ओवरऑल जो है कंक्लूड यही करूंगा आप लोगों को कि
अगर आप लोगों को कुछ पूछना हो इन रिस्पेक्ट ऑफ ट्रेडमार्क, ठीक है, क्योंकि आप अगर मार्केट में उतरेंगे, ठीक है, जहाँ से पैसा बनेगा आपका टेक्नोलॉजी से, तो आपको जो है मैन्युफैक्चरर ही पैसा देगा, ठीक है, या जो यूज़ करेगा, लेकिन जो एंड कस्टमर है उसके पास आप अपने ब्रांड से जाएंगे। तो कुछ आप लोगों का है कोई क्वेश्चन, सवाल जवाब? ठीक है, तो कोई दिक्कत नहीं है। आज का जो है सेशन मुझे वाकई में बहुत ही नॉलेजेबल सेशन रहा है। नॉलेजेबल इन द सेंस क्योंकि जब रोशन जी आए उन्होंने भी काफ़ी मतलब ज्ञान वाली बातें की। जो रुचिका मैम आई उन्होंने जो है इनोवेशन वाला पॉइंट बोला, वो वाकई में सच्चाई है हमारे देश की, ठीक है। आपका जो इन्वेंशन है, दैट्स इन्वेंशन और इनोवेशन में उन्होंने फ़र्क बताया, बहुत अच्छा रहा। और जो है ओवरऑल जो है आज के कार्यक्रम के लिए मुझे पता चला कुछ एक हफ्ते पहले ही आपका जो है कार्यक्रम प्लान हुआ था, ठीक है, हफ्ते 10 दिन पहले। इतनी जल्दी इतने कम समय में सोनम मैम ने इस कार्यक्रम को ऑर्गेनाइज किया, ये कोई छोटी मोटी बात नहीं है। आप लोगों को मतलब बच्चों को लग रहा होगा कि हमें केवल इनवाइट करना पड़ता है लोगों को, बहुत मेहनत लगती है मैनेजमेंट करने में, लोगों को कार्यक्रम को ऑर्गेनाइज करने में। तो मैं जो है सोनम मैम का बहुत बहुत धन्यवाद करूँगा। आई थिंक एक मिनट टाइम बताइए। ठीक है, अब आप लोगों को कोई क्वेश्चन नहीं है? ठीक है, अभी जो है ना यहाँ पे कुछ चीज़ें शायद मतलब मैं मुश्किल से 2-3 मिनट लूँगा, क्योंकि आप लोग इंजीनियरिंग के हैं, टेक्नोलॉजी से जुड़े हुए हैं। एक सेगमेंट है जिस पे शायद डिस्कशन हुआ हो, नहीं हुआ हो, एक बायोलॉजिकल डाइवर्सिटी और जो आपके प्लांट वेराइटीज़ एंड फार्मर्स राइट है, इस पर भी कुछ कानून बने हुए हैं, इनको भी प्रोटेक्ट किया जा सकता है। क्या होता था पहले जो है ना, पहले आपका नेचुरल प्रोडक्ट्स को पे आपको पेटेंट्स नहीं मिलते थे, तो इसके लिए फिर बाद में अलग से कानून बनाए गए, ठीक है। तो इसमें प्लांट वेराइटीज़ प्रोटेक्शन एक्ट वगैरह हैं, आप लोग इसमें जा सकते हैं। अभी तक मेरे ख्याल में किसी ने यहाँ पे सुना नहीं होगा प्लांट वेराइटीज़। एक्चुअल में होता क्या है कि कहने की बात है कि ये सब नेचुरल है, लेकिन जो जो फार्मर्स होते हैं, जो रिसर्च में इन्वॉल्व रहते हैं, बायोलॉजिस्ट, ठीक है, वो मतलब आंख बंद करके तीर चलाते हैं और सालों तक चलाते रहते हैं, जब तक वो जो हाइब्रिड वैरायटी बना रहे हैं, ठीक है, जब वो हजार 2-2 हजार 5-5 हजार एक्सपेरिमेंट्स करते हैं, तब एक एक वैरायटी बनती है। तो उनको भी जब रियलाइज किया गया कि उनको वो भी जो है उसके कंसिडरेशन के लिए एलिजिबल हैं, वो फ्री में नहीं कर रहे थे मेहनत। मैं चाहूँगा कि इस मंच के माध्यम से मैं बोलूँगा लोगों से, यहाँ पे इंजीनियरिंग में भी वैसे तो वो जो है फील्ड है बायोलॉजिस्ट के लिए ही होती है, ठीक है, मेनली बॉटनी वालों के लिए, लेकिन आप लोग भी चाहें तो इसमें आगे बढ़ सकते हैं। आई थिंक ये जो है सेशन का टाइम भी हो गया, ठीक है। और आप लोगों को समझ में नहीं आया कुछ मैंने बोला आखिरी में? टीवी टीवी पे चलवा दें?
Thank you very much, sir. I would like to call Dr. Rajesh Prasad, Professor in charge, for presenting a gift to Mr. Divesh Agarwal as a token of thanks. Thank you, sir. As we conclude this enlightening exploration of IP rights, remember, you hold the power to shape the future, empowered by knowledge and protection. I would like to call Dr. Sonam Gupta for vote of thanks.
Jai Hind, all of you. On behalf of Department of Computer Science and Engineering, Ajay Kumar Garg Engineering College, I stand before you to deliver the vote of thanks for this enlightening workshop on IPR, which is funded by CSTUP Lucknow. First and foremost, I would like to extend my heartfelt gratitude to Dr. R.K. Agarwal, Director AKGEC, for providing us the platform for conducting this workshop. I also like to thank Dr. Anu Chaudhary, HOD CSE, for guiding us and providing us a continuous support for the same. I would like to thank all the participants, the organizing team, the speakers, all of you for your valuable time. Thank you so much, all of you, and we look forward for your continued support in the future. Now I request all of you to kindly proceed for the evening tea. Thank you.